What's up, guys? Good morning, good morning, good morning. What's up, all? Good morning, good morning, good morning. It was a pretty fun day yesterday with Woody in court yesterday. He's supposed to be back Monday. Monday at 8:45 a.m. She still hasn't ruled on the mistrial. And remember, the last live I did, I was like, wow, her tone sure changed. And I think it did. But then the next day, it seemed like yesterday she was kind of back to, let's move forward. Granted, she still hasn't ruled on the mistrial. And then there was another disqualification motion. But she's going to do something about something. Like there's going to be some kind of harsh words for it. But the idea that she would just dismiss this entire case, and when you look at the indictment, I mean, the idea that any judge would, the Shamel Drinks case is in 2022, the murder, and we still haven't even heard any evidence of that. But the idea that any judge would dismiss all those charges with prejudice, like make it so they could never be recharged again, I think that's unlikely. And that has to be a factor for Whitaker too, looking at the indictment and some of the charges in there. But again, I always said the biggest problem with Glanville was just his mismanagement of the trial and how he never started on time. There were always like big 2.5-hour breaks. It would take him like 2 weeks to get through one witness. I'm not really sure if streamlining the case and returning the focus to the witnesses and the evidence, doesn't it benefit the defense to have all that gap in the prosecution's case and everything? But when I talked to Doug Weinstein, he was saying that any kind of efficiency in trial benefits both sides, and I think it'll be good for the defense to have more efficiency from the bench. But when you look at how their legal arguments go, like I've got a bunch of clips to post this morning from the discussion about Quamarvious Zachary's statements they want to use. Max Shard's arguments about what should be excluded, he didn't win a lot of them. And what's interesting is there's no way Glanville would have been getting through that kind of discussion so fast. And what's original with Judge Whitaker versus Glanville is the fact that Whitaker is even doing this Quamarvious Zachary statement, because she had asked the prosecutors, like, who are the witnesses coming up later after Woody? Let's look at them and get ready for some statements that you might need to ask them on impeachment or whatever, and get ahead of this. So that's what they were doing yesterday. I'm not sure if they're doing more of it today, but Glanville never did that stuff with them. He had terrible leadership skills. He never did any kind of planning ahead to look at, what's coming up, what's asking the attorneys to get ready for evidence for the next witness, that kind of thing. So she is definitely way, way better at that. But again, I'm not sure if does it benefit the defense. She hasn't made too many. She's come down on the prosecutors a lot more. She's obviously aware of some problems there and everything. But again, when you look at how the legal discussions were going yesterday about these Quamarvious Zachary statements, she was not giving the defense very many wins. And I watched the entire discussion with Glanville over Woody's past statements. And then I've watched the entire discussion with Whitaker over Woody's past statements. And I don't have an exact list of what she's allowed in and what Glanville didn't. But again, it's not a lot of wins for the defenses. She's shooting down their arguments pretty quickly and not letting them just talk forever. And not that they're trying to talk forever. It's just when Glanville was sorting through these statements, he would be asking all these questions of them. It would take him 45 minutes to get through one statement to decide whether to allow it or not. And then a lot of the times his decision would just be, oh, we'll see what happens. You have to lay the foundation, which still isn't really deciding it. Whereas Whitaker is taking a much more decisive stance on this stuff. Her average for dealing with one statement is 9 minutes or something. She gets through it, hears from both sides, make a decision, move on. Whereas, like I said, Glanville was just kind of all over the place and then never making a decision. So we're definitely seeing some more changes that way, but especially when Max Shard gets up there and argues, against statements coming in. And I mean, a few here and there, but nothing too big, and a lot of wins for the prosecution. But one, and I'm gonna post this as a short clip this morning, but one thing that jumped out to me yesterday is Whitaker was skeptical of something the prosecution wanted to bring in regarding, apparently it's a statement, maybe Quamarvious, Zachary, or somebody else. They're like celebrating the fact that Lakia Gaither is no longer a detective with the Atlanta Police Department. And Whitaker is just like, okay, gang members celebrating that Gaither is no longer a detective. How is this relevant? And Adrienne Love just like immediately backs off on it. She's just like, well, Judge, I'm not really committed to that one. I just kind of liked it. And that is like a prime example of the problems with these prosecutors. They again, defense attorneys can throw anything at the wall to see what sticks because they're trying to defend their clients and they need to come up with the best argument possible. But when you're a prosecutor representing the state and you're like taking away people's rights, taking away their liberty, rights, while you're putting them in custody, you need to have like more of a cohesive narrative. So for her to just be like, acknowledge that piece of evidence she wanted to bring in wasn't relevant, she just thought it was funny. It's like, okay, I don't know. She always does stuff like that. Like it's just like unprofessional. She doesn't make it better for herself, But I think this morning, no Woody this morning. I mean, after yesterday, now everyone's highly anticipating his return to the witness stand on Monday. And I think everybody probably saw the clip where she just straight up asked him, like, are you going to testify? And he said, it depends on how I wake up. But she did tell him, this is Judge Whitaker, she thinks that Glanville was wrong when he said that Woody can stay in jail for the duration of everybody's trial. She said she thinks it's only this trial, and she predicted that the trial could end in February or March 2025. And that must be a good goal for her, just how efficient she is. I'm like, okay, I could see that happening. So she did tell Woody that if he doesn't testify, because he has the immunity order, if he tries to plead the Fifth or anything like that, it's the same situation it was with Glanville in that he'll be jailed for contempt of court. But the difference with her is she does not think that he can be jailed for the duration of everyone else's trial, which, God, that could be like 10 years, I mean, she told him this trial only, and it could be February or March 2025. So Woody right now has got to be like weighing what he should do. Should he just go stay in jail for March till March 2025? And also the idea that if he doesn't testify, if he just decides, no, I'm going to go to jail and like try to save my reputation as a snitch that I got, from doing all those interviews, the trial might not. I mean, you wonder what prosecutors are going to do because he's such a key witness in their whole case. I mean, I doubt at this point if he didn't testify, they would just drop it themselves, but it would not be good for them. So he has a lot of. I mean, Woody has a lot of like power right now in the whole thing, and it's just like, I mean, personally, I would not be willing to like go sit in jail for 6 months just because I didn't want to testify in a trial. But I'm not Woody. I mean, I don't know. He's got a lot of things to consider right now. So if he does do that, it's gonna be wild. But then also, if he does decide to testify, it's gonna be pretty wild. So, but that's not till Monday. They're gonna have the jury back on Monday. But the way this case has been going and the way the judge has been going, I don't want to say today's gonna be boring because who knows? She could issue her ruling on the disqualifications. She could issue her ruling on the mistrial that requires the analysis of the ex partes. So something could happen today, but there's not going to be Woody in court. And I think they might just be going through more Quamarvious, Zachary statements, but we'll see. We're like 2 minutes away from the 6 a.m. start time. She said 6 a.m. today, but she said when it's the jury, it'll be 8:45. So it is 5:58 a.m. here in Los Angeles, and I am up for you guys. Remember, it's East Coast, West Coast time. I read all times in ET versus PT now, but yeah, somebody else says I think he will sit. It It's interesting. And then if he does just decide that this was the same issue with Glanville, where if he just decides not to testify and he's in jail, are they going to bring him back out every day to ask him if he's changed his mind and he wants to testify? I don't know. There's a lot of unknowns here, but hey everybody, thanks for saying hi. I got to greet everybody here. JG, somebody else said hi earlier. Good morning. Good morning. Good morning, Hood Info. Nikita, what's up? Hot Sunday says I'm awesome. Thank you. Thank you. I love this trial. And my YouTube channel is kind of blowing up too. I'm getting more subscribers, getting more. And that's one thing I do have. I haven't really promoted the channel subscription at all, but I do have it set up. And I notice I've got 3 subscribers, 3 new members on there. So I want to do something to spotlight you all and talk to y'all. So we'll do that later. God, I sound like the judge saying y'all left and right. Good morning, Gloria. Good morning, Mimauli. Do you think it's 50-50 for charges to be dropped against Thug? No. When you look at that indictment and all the charges, I mean, especially the Shamel, of course, he's not charged with the Shamel Drinks murder, but it's an overt act in the RICO conspiracy. I mean, the idea that any judge is just going to throw out that entire indictment with prejudice, it's like, I don't think so. Like, there are some pretty serious charges in there, you know? I mean, it's going to be interesting to see what she does on the mistrial and her ruling on the ex partes. Because remember, she said that she'd gotten through most of Shard's motion about, except for the Brady violations. And it seems like she had some concerns about the Brady violations, but just the way she's going forward, I don't know. I don't think she's doing a clear mistrial, but, and also if she does declare a mistrial, it's not going to be with prejudice because they'll just start over. So, and I don't think she wants to do that. So, 5:58 in Arizona. I've got family in Zona. Nina, you are welcome. Love getting up early. Somebody once told me, and as you get older, you're able to get up earlier more. But when you get up early, you never regret it. It's not like later in the day when you get up early, you're like, oh man, I wish I just slept in. And that says something about it. Like, you got to get up early. You'll never regret it. Hit the like button, everybody. Let people know we're here. I see it's 6:01, but this one that I have up is sometimes kind of late, but I've got the law and crime feed up, and they're not on yet either. They're usually pretty on the ball. But with her starting so early, sometimes it just, like, you don't have the long intro of, God, he would take roll. It was like a teacher, you know. 9 a.m. Is Woody safe? I don't know. I mean, he's going around Atlanta, you know. It seems like he can take care of himself. I don't know. Oh yeah, no court on Friday, or at least in the morning. She was saying she had something to do. So I think she kind of left it open that maybe they do an afternoon session, but maybe I missed that she said no. Yeah, I got to get up early on the West Coast. I got like totally addicted to this trial. It was back when Trontavious Stevens was testifying. I was like, okay, this is good. And then I started doing the channel and doing all the clips, and that kind of becomes a little demanding. But you know, I built up this huge channel. I can't stop now. I was there during the dry weeks of the Honda crashing into the Infiniti crashing into the laundromat, you know. 8 a.m. here in Kansas. Anything proven so far? It's up to the jury. I mean, the case isn't over yet. Yeah, don't forget to hit the like button. Ramsey's right. You guys got to hit that like button. Let people know we're here. Okay, it's 6:02. I still don't see him. But again, the law and crime feed is the one that's like, no, they're always first on it, and they're still not up that I see. Yeah. A lot going on. Tom Girardi's on trial over in LA federal court. But the electronics restrictions are insane. I can't bring anything in there. I got to check my laptops at the door. I got to put my phone in a pouch. I am going to go in there today for some of it. But yeah, I'm not going to be covering that much. And of course, it's one of those trials that everybody is covering. I'm going to send something out to my mailing list about it. And I'm like, yeah, I didn't write something on openings, but you can read 5 articles about opening statements here. You know, I'm going to be there for the verdict for sure. But yeah, the Vlad interview. Yeah, they gotta. He always puts the camera up like the worst angle. You know, it's just dumb. Do you think Love will be disqualified? No, I don't know. I mean, I thought the thing that really, like, if anything was going to catch her attention, it would be the testimony from Detective Long the other day that they did have an off-the-record discussion during that ex-party about Donovan Thomas's killing. It wasn't Woody confessing to it, but it was Simone Hilton telling Kayla Bumpus if Woody says that he killed Donovan Thomas, I'm going to prosecute him for perjury because we think he didn't do that. We think he's lying. So I thought if there was going to be anything that caught her attention, again, I don't think that rises to the level of she's going to dismiss all these charges like the Shamel Drinks murder case and make it so nobody can be ever charged again. But I thought that would catch her attention and could be a problem. She seemed to have a different tone yesterday, but she also didn't talk about it at all. She's going to issue a written ruling. A written ruling about it. So maybe we're going to hear about that later. Still no Law and Crime. Dude, the whole idea that Vlad is actually an FBI informant, he doesn't fucking do anything. FBI informants are people who like actually like they don't just like sit down and do interviews with people. Like, I mean, what does he have access to that people think he has like inside information that he's somehow getting from people? Bumpus, the 15 minutes of fame seeker. I kind of see her, especially right now, as being extraneous to the case. I mean, she all of a sudden became relevant the other day when she testified. But gosh, I don't think I don't think the judge would have believed that there was like an off-the-record ex parte just based on her testimony. Because, I mean, everybody saw how skeptical the judge, Whitaker, was of her. But then Detective Long went and confirmed that there was. And it kind of with Detective Long's testimony, it's like, who cares about, you know, what Kayla Bumpus said? But I don't know. Somebody said this is Vlad, and I shouldn't even entertain it because it's so silly. The whole idea that Vlad, every time someone comes on their show, they get arrested. It's like, okay. Usually when you read what they've been arrested for, you can kind of get an idea of like what caused it. And if there was an informant in play, like you might, it's like, oh, some guy did an interview. Oh, well, let's arrest him. I mean, it's like, you guys are going to need more than that to accuse people of being informants. Dang, I thought Tom Girardi was dead. He practically is. He walked into court yesterday, and he's faking it though a little bit. He's definitely has some dementia and Alzheimer's, but this whole thing about him just being completely out of it is bullshit. Okay, here. Ooh, I see something.
Consider it Brady material was made, but his act of his what the Atlanta police went on to get the search warrant for his cell phone records is material that have been provided to the defense.
So you say that Mr. Boyer's existence was revealed in the wiretap that the defense has had for a while. And is his phone number and the number of times he was communicating with Garlington is stuff, that information that the defense has had for quite some time. Is that right?
Yes.
Okay. When did APD secure anything, and it may have been these cell phone records, that caused them to believe he was in the car with Mr. Nichols?
It was reviewing the wiretap data, which caused them to say, oh, this person looks like he's a part of this.
Okay.
And then looking at the number of times and the types of communication between them, they're able to see data exchanges. They were able to compare it to the time that we believe the murder occurred.
Okay.
And they were able to follow on the surveillance footage that we have the path of.
Okay, so I mean, basically the raw data from which they reach these conclusions is all from the wiretap?
Yes, it's from the wiretaps. And then when they got the cell phones based on what they saw in the wiretaps during their investigation. And I believe that as it relates to the Waters Road incident that occurred during that same time, they were able to, this is still information in the wiretap, but there was communication from Mr. Boyer about what was going on at the Waters Road incident. That's a part of the data that's included within the wire information.
Okay. Have you, meaning the DA's office or APD, conducted any interviews of Mr. Boyer?
No, not only no interviews, no warrants have been secured either at this time.
All right. I'd like to review the affidavits in support of seeking I assume you got cell record, cell site info, and then you separately got contents of cell phone, or did you not need that because you had the wiretap stuff already?
We because no one had any contact with the person himself, we never had access to contents of his cell phone, just his cell phone.
Okay, so when we're saying cell records, it's essentially like location information.
Yes.
Okay. All right. So can you get me the affidavit in support of that, please, to review? Yes, sir, Mr. Sharp.
Your Honor, regarding the state's assertion that we were put on notice about Mr. Boyer, there is a wiretap. That is true. We were provided the contents of the wiretap. That is also true. There's nothing in the wiretap. There's a phone number, which is what the state handed over on Monday, the contents of that phone number that shows contact through the wiretap. There was nothing linking that phone number to Mr. Boyer. I just want to make that clear.
Okay,
There's nothing that puts us on notice that Mr. Boyer is a person of interest or potentially at all involved or in contact with our clients in this case. And there was also, Mr. Harvey's also pointing out there was no raw data provided in the wiretap regarding the wiretap itself.
Okay, I guess when I said data, I meant the information from which they formed those conclusions.
I understand. We were aware of what numbers were calling what
You
numbers
just
at what
weren't
time.
aware that whatever this number is was connected. It's obviously somebody's, but y'all didn't know whose phone
Correct.
it was.
And I can state in my place as an officer of the court, upon information and belief, that I've listened to pretty much all those calls. I don't recall in any calls in the wiretap where that number's involved, anyone ever saying any government name that would put us on notice and say, oh, that's DeMarco Boyer's number. So we've been pretty diligent.
Okay, so Ms. Love,
Yes.
what do you say about that?
I'm not refuting the person's name. I'm talking about the phone number whose records we turned over being present and the content of his conversations and communication.
Okay, so do you have the affidavit available?
That's what I'm getting.
Potentially by the time of the affidavit, but certainly by the time the cell records were secured in the fall of 2023, you knew that phone number was connected to DeMarco Boyer, true?
That is true.
Okay, so is there a way that the defense was supposed to have also known that that phone number was connected to DeMarco Boyer?
If the court will permit me 1 second.
Go ahead.
Will the court permit one of our team members to step outside of the courtroom and make a phone call to expedite this obtaining?
Yeah, absolutely. Unless you are the one who needs to step out and you're the one in the midst of the argument, the rest of your team can do whatever they want to do. Okay?
And Your Honor, just from memory,
Yeah.
I do know and believe that there's a reference to not his given name, not his formal name, but to a nickname. I'm getting that information.
In the wiretap?
Yes.
Okay. One other thing you were going to do, well, a couple of other things today. We discussed yesterday providing the exhibits to the extent they're currently ready with the rest of them. Has that been done?
Can I give that to you at lunch? She's still working on it.
Okay. Okay, and co-conspirator statements, the same? Okay. All right, any idea timing on this?
So our legal assistant is working on getting the affidavit.
Okay,
The nickname listed in the okay, so the wiretap affidavit was served in discovery 2 on 8/22/2022.
Yeah.
So we're just
I'm not looking for the wiretap affidavit. I'm looking for the affidavit to get Mr. Boyer's cell records. I don't assume that was served in discovery, was it?
I'll check.
I-
Should not have been, because the reason that the phone records weren't served was that they were considering arresting him.
So the answer is no on that one.
Correct.
Two things, Your Honor. First, yesterday we were told that it was, to my understanding, an inadvertent oversight by the state to hand over these records. Now we're being told it was a conscious decision not to hand over the records. Secondly, regarding the affidavit for the search warrant for Mr. Boyer's, presumably Mr. Boyer's phone records, I specifically requested that yesterday via email, and I haven't received it either.
And I reached out to the investigator who got that last night. That person, I can provide information to the court and Mr. Chart as to what is happening to the lady that on their end.
Is there some reason that can't just be shared right here and now?
They're trying to thwart a murder.
They're trying to do what?
Thwart a murder that is underway or being.
Okay, then seems they should pass off the responsibility for getting the affidavit to someone else.
My legal assistant is looking for the affidavit.
Did you in any way respond to Mr. Sharp?
No, I didn't see the affidavit email. What we were trying to get last night was the information about the phone records. That's where I got part of what I provided to the court this morning. What I'm waiting on is my legal assistant, because the person we were able to communicate with at the door said, the lead investigator said that the affidavit was provided to us. So
The affidavit was provided to us as in, I don't know what.
Turns out, I'm sorry.
Well, I mean, I would assume so.
So we have it, we should have it to give to Mr. Sharp and to the court. I'm awaiting that to provide it to the court, Mr. Sharp.
Okay, and so you didn't see the emailed request from Mr. Sharp last night that said, could we please have the affidavit in support of the cell record?
I did not, and the court is welcome, Mr. Sharp is welcome to look at my email.
I'm sure you get a lot of emails.
I did not see that. I don't even know what time he sent it, but I did not see it.
And I want to be very candid with the court. I sent this to Mr. Atkins because he was the one that sent
Oh,
the
okay.
information.
Well, that's why you didn't see it, Ms. Love, because it wasn't sent to you, it was sent to someone else.
Because he was the one that sent us the phone records. And I want to be clear, and I think it's clear what I wanted, but my email said that I wanted to see the search warrant, which we haven't received either. Obviously, I meant search warrant and affidavit, but I
Okay.
did put search warrant. But we haven't received either.
At what time did you send that? It was,
1:53 p.m.
so yesterday afternoon. Okay. Okay. Okay, so I understand that I can't remember who just stood up and raised it, but whomever said that yesterday you said it was inadvertent, and this morning you're saying there was a decision made not to share this information with the defense because Mr. Boyer had not yet been arrested and APD was contemplating whether to secure a warrant, and I didn't want to alert him. So which is it?
Thank you. They are both. I asked the court yesterday, so allow me time to speak with team members.
Right.
And the information internally that I know is that when the phone records were initially secured.
In the fall of 2023.
Yes, yes.
Okay.
When they were initially secured, the thought process was, we're going to get this person arrested and indicted.
Okay.
As time went on, our team had the records, and as we advanced in trial,
do you know when the decision, if there was one, was made, okay, we're not going to get a warrant for him after all?
I don't think that decision was ever made, because talking with the lead investigator who got the records last night, there is still frustration because they get permission to get the warrant, and their efforts have not yet been responded to. So they're waiting. That person wants a warrant. So there's not, the decision to obtain the warrant has not been abandoned. The
Okay.
efforts to obtain it have not been abandoned, but we are at a place where it occurred to team members that, oh wait, we have this, we need to give this over. And it wasn't time progressed. It was in our possession.
Mm-hmm.
It occurred to team members. This is something we can't wait for a warrant or arrest on. All of that is true. And I would have to consult with our team to see when they ask that those records be plotted, because at that point, I know that would be something that, at least in our minds, we're thinking, we could use this. So I could get that date as well, the date that they were sent over to be plotted.
Okay. Because, I mean, do you think that it's reasonable that at least by that point, you should have shared that information with the defense?
I think that when we're talking about realization and oversight, that at least at that point, if not sooner, at least at that point, that is when it was, oh shoot, I should have turned this over way earlier, at least 5 days. So initially there was this belief and understanding that there was this investigation that would lead to an imminent additional person charged. That has not occurred. And there was the realization that we have in our possession this data that we need to turn over.
Are there any outstanding warrants for any other things for Mr. Boyer?
Yes, I believe he has, not here. I believe he has, I think he is in jail for a murder, but I think he is in jail in another county, not here, but I think he's in jail.
For like a pending murder? Not a pending murder. The murder has already happened, the murder that is he charged or is he just?
Charged, I believe he's charged for a murder.
Okay.
I have no
Do you-
details about that murder. I have no details about. that.
Okay, but he is in custody somewhere in Georgia facing charges.
Yes, the capital.
So does the state intend to try to talk to him?
We were not going to talk to him.
Okay, does the state intend to use this plotted out, whatever y'all got about his cell phone location at different times?
Not unless, so no, not.
All right, and all the information you have, you, the state, have regarding Mr. Boyer is inculpatory of these 6 defendants, or not all 6 of them, whomever is charged in the Thomas murder?
In
Drinks, oh, okay, okay. Which is something that other than your opening, which isn't evidence. Have you gotten to that point in the evidence yet?
No, that would be likely one of the last.
Okay. All right.
I feel like there was another question the court asked me that I did not answer.
I don't know what it was at this point. All right, so I will, whenever it's forthcoming sometime today, get and share if I assume Miss Love's going to share based on the request, the affidavit in support of and the search warrant and with the defense and also with the court, right? Okay. So we will await that. And then if anybody wants to argue anything concerning it, I will listen. The fact that this has to do with the drinks murder makes it a little less well, strike that. If y'all want to say anything else after we get those, then I will entertain it. Okay. All right, so in the meantime, let's keep plodding through this set of statements of Mr. Zachary's.
Can I ask a date or a date certain for the court to inquire of a date certain on this issue before you?
On the debt, on the getting the affidavit and the search warrant?
No, on, I'm just, I'm sad saying that. I'm really hurt saying this, but this is not new. So a date when Miss Love just said, oh, shoot, this is not a quote, but something effective. Oh, shoot, we must turn this over. That was before giving it to Agent Bernie. So what happened on that date of the oh, shoot, till we get it yesterday? And we don't get it with, like, oh, this is new stuff. Let's
Good
talk
question.
about it.
So we are one team, but we have many members and parts, but I will get the date. But I can tell you that when I said that there was the realization that we do need to turn it over.
Yeah. When did that realization occur?
I will find out because it was not mine. It was not my realization.
Okay,
So I'll find out. What I'm saying is,
who's in charge of the team?
I am. And so before
Okay.
it's mine, generally speaking, I'm saying that in terms of a date certain, there was communication internally. We looked at it. We were looking at everything we had to turn over, and we were looking at anything that we haven't turned over collectively we realized, oh my goodness, this has not been done.
All right, and you don't know what date that happened?
No, that's what led to turning it over.
On Monday.
Like, yes, this weekend we were talking about it and we turned it over.
All right, so sometime over the weekend is when the realization occurred, oh my gosh, you knew you hadn't turned it over. Oh my gosh, we need to turn this over?
Oh my gosh, it has not been turned over and we need to turn it over.
Okay, and you're getting us the information about when when we get the affidavit in support of the search warrant for the cell records, we'll know the date that occurred.
That is correct.
Uh-huh.
We're working on that.
And it did not occur to anybody at that point in time that this is information to be shared with the defense.
When the court says at that point in time, you mean with the affidavit for the search warrant? When the search warrant for the records were obtained?
Yes. Right? I mean, obviously not, since
No,
you
because-
got them in the fall of 2023.
And because the information that the search warrant was based on had been provided. So
Well-
we weren't thinking along those lines then.
Okay, had you at any point provided information that the phone number that y'all all know about from the affidavit and the nickname, which I think that's what it was, you were going to tell me what the nickname was, is actually DeMarco Boyer. Did you ever before Monday share that information?
No,
Okay. All right, what was the nickname?
Unk is
Unk.
the name that's listed on, I think in the wiretap, I think it's.
Okay.
Unk. That's. And I'm also seeing if there are any other nicknames associated with that number. There may be more than one. That's not uncommon. So I'm gonna get all of them. May I step to the door once more?
Yeah, and before you step to the door, is there at this stage, which is mid-trial, anything else, whether Brady or not, that you think might be relevant to either the state or the defense in trying this case that you, the state, know of that the defense still does not know of? And you may want to huddle with whomever comprises your team, and y'all all put heads together and really, really, really think about that, and then get me an answer after lunch, okay? Can you do that? Okay. Yeah, just we'll recess in place until you come back from whatever you're going to find out at the door now.
Thank you. And since we're recessed in place, I'll just sit here.
Okay.
Hey, all, that was interesting. Judge kind of taking a harsh tone on this here. You know what? I am going to switch over to another feed so we don't have the huge law and crime signal on there. I do this on another computer, and sometimes when I do it, the sound kicks, and I have to correct some stuff. So it's good to do this when they're not actually talking. Okay, yeah, the sound kicked on that. So let's see. I'll get it back here in just a second. We're not missing anything. So yeah, we'll see what they come back here. That should have volume. I think we're good here. Wonder how long they're going to take. It's still early over here. I got to go do some breakfast stuff, but see, again, all the calls for mistrial and it can't be tried again. It's like there's just so many charges there. I mean, the Shamel Drinks case just like Shamel Drinks was 2002 murder, or 2022, excuse me, and we haven't heard any evidence of that yet. So I don't know, the idea that a judge is just going to dismiss that entire indictment with prejudice, I don't know, but we'll see. Because I think if she does call a mistrial, I'm not sure if she would end up dismissing the case with prejudice, but we'll see. I'm gonna step out here, but thanks for tuning in, guys. Hit the like button if you can. People who say it's corruption at its finest, it's like you need a quid pro quo for corruption at its finest. I mean, you would need some like sign of like payoffs and stuff like that. Like who's charged in Shamel's murder? I know it's Shannon Stillwell. I know I haven't brought up the indictment here. But yeah, so I gotta go do some stuff. But anyway, thanks for tuning in, guys. I'm still here. I've got some clips from the Quamarvious Zachary discussion to post yesterday, so check those out. But hit the like button. Let everybody know that we are here. The channel is kind of getting some more attention. I'm glad to see that. But I've got some interesting discussions yesterday about the Quamarvious Zachary statements in addition to everything that's up. So well, it's Anthony. I mean, it's a good point, but it's still up to the judge whether she attaches makes it so double jeopardy attached. And I'm thinking that if she does do anything like that, she's not going to make it so there's some kind of double jeopardy attachment, especially to a charge like the Shamel Drinks murder, when they haven't heard any kind of evidence about that. And it's just it's too big of a case. But the idea that the judge would like do something to allow it so that charge just like nobody is ever going to be recharged in that, I'm like, I don't think so. So anyway, we'll see what happens. Thanks for tuning in, guys. Hit the like button. See somebody saying, yeah, and I quickly corrected myself to 2022. Anyway, see you guys later. Yeah, that's not true, because in the Ebenati case, it was a mistrial. It's just inarguable, and it's up to the judge's discretion about whether there was actually goading attached to a mistrial. And I'm telling you, the judge isn't going to like find anything like that here. Like because I mean, the Michael Avenatti case, when Judge Selna declared a mistrial, it was because of prosecutors hadn't released information from Michael Avenatti's seized law firm servers that he said could be considered Brady. And the judge ruled that it should have been released, and it was prejudicial to Avenatti to not have it, that he needed to be able to prepare for his opening for all that. But he did not declare goading by a prosecutor. So it was a mistrial, but he was just going to be retried. And I think that's what would happen here. But anyway, I got to go. It's too early. I got to do some stuff here. But see you guys.
Something else in the meantime? All right, thank you.
Your Honor,
Yes, sir.
can I just add one thing to previous discussion?
Sure.
A lot of the state's theory is that Mr. Williams is in charge of a gang and the gang does crime on his behalf. He asks for it and they do it. We deny that. I heard the court say, and I heard prosecutors say that this is inculpatory, no exculpatory. Everything could be inculpatory or exculpatory.
Okay. Can I just,
Of course.
I didn't say it's inculpatory. I don't know. I said the state, I mean, if I said that, I'm repeating the state's maintaining that it's only inculpatory.
I understand.
Okay,
And
go
I
ahead.
appreciate it. And all I want to make the court aware as you go through decisions is if we knew about Mr. Boyer, then what I would have done is found out if he has a lawyer, because he's in custody, it sounds like, contact his lawyer, ask if I could go with the lawyer and Miss Adams, when I say me, and Miss
Yeah.
Adams, and an investigator, and interview him. And he may give information that's very hurtful to me. He may give information that is very beneficial to Mr. Williams. I don't know. My point is, though, that the state has no ability to know what's helpful or hurtful to Mr. Williams, and we have a right to investigate. So I just wanted that on record. Okay.
I don't disagree. Thank you.
I don't disagree.
All right, Ms. Lev, if you're at a stage where you can shed any further light on anything, great. If not, we'll take it up after lunch.
I'd like to take it up after lunch. if the court
Okay.
allow me. And I wanted to make clear, I'm not refuting anything regarding the need to provide it to the defense and whether it's inculpatory or exculpatory. I just wanted to make clear and make sure that I told the court and the defense that we're not asking to use it. We just wanted to, out of abundance of caution, in the event that it is in some way, in any way exculpatory, give it to the defense. We're not trying to use it.
Okay. All right, thank you. All right, let's turn back to Mr. Zachary's statement we were going through yesterday. And Ms. Love, you were going to take the overnight recess to try to determine if there are parts of the proposed redactions that you agree to. And Mr. Shard, I know, I don't know if it was you or Mr. Atkins that shared the the 3 pages of the proposed redactions with regard to this interview that we're going through right now. And honestly, there's not a date on the binder that y'all gave me, so I don't know what date to reference, but you have proposed redactions for the other interview. Can you share those as well, so I have something to go by?
I will. I'll send them over right now.
All right, thank you.
And Your Honor, just the record, number 38, which is the next one according to my record, I'm withdrawing my request on that.
Okay,
We don't need to-
thank you. And what is the date of this interview?
This one is April 27, 2017.
April 27, 2017. All right,
No,
thank you.
April 13,
13,
2017.
2017. All right, thank you. Okay. So, Ms. Love, I know you're looking for them, but did you get an opportunity and are there redactions you agree to?
There were not a lot. There was
Okay.
only one.
But you're gonna find whatever that was and let us know.
Right.
Okay.
And I marked them in the transcript. Actually, the one that I thought that I did agree to, oh, okay, here it is. So number 76, again, the discussion about the injuries
Right.
of certain part of the body, and that would be page 259, line 20.
Yeah, so you agree that that should be redacted?
Yes.
And that's the only one between 39 and 75 that you agree to?
Yes, and the reason that that is the case, I'll just say that I went back and was listening to the context. So
Yes.
I did read Mr. Sharp's reasons for wanting to exclude it, but I want to just make sure that it wasn't necessary for a larger reason, and I'm prepared to express and
Okay.
explain why those are.
All right, well then let's just get back to it. We're on number 39.
So, Your Honor, number 39, I was shorthanding this when I wrote Yak.
Sure.
When I wrote Yak, that's Mr. Kendrick's.
Okay.
So my understanding from my recollection is that Investigator Dennis has never spoken to Mr. Kendrick's about the murder of Donovan Thomas. Okay, that's my understanding. But either way, whether he's spoken to him or not, I believe he's just using a technique to try to suggest that Mr. Kendrick has said things.
Right. Excuse me.
But to the extent either way, he's putting words in Mr. Kendrick's mouth. Mr. Kendrick may not take the stand. That's up to him. But I don't think it's appropriate for Investigator Dennis to state on a out-of-court statement for the jury to hear what Mr. Kendrick supposedly told him about the events of January 10th, 2000.
And Your Honor, that's at the bottom of,
Yeah.
and I can also provide the court the timestamp for it on the video that we just given, but it's at 16:32 in the video of this portion of the interview. And when the court is prepared for me to, I can respond.
I'm prepared for it.
So Judge, I hear and understand what Mr. Shard is saying. I disagree with it. When Investigator Dennis says that Yak said something different, and nowhere does he assert, hey, I did this. Everyone knows there's not a dispute. I think that Mr. Kendrick made a statement and said something different. And when Investigator Dennis says that Yak said something different, just to give the court some context, the 2015 interview that this witness gave contained inculpatory information concerning Mr. Kendrick, Mr. Stillwell, and others.
Okay.
By the time we reached 2017, it has been circulated that interviews have been conducted. Jail calls revealed that co-conspirators, at least alleged co-conspirators, people that we allege are co-conspirators, are aware of the content of some of these interviews. And at this point, Mr. Zachary is now saying he's backing away from it. He doesn't deny, he never denies that defendant Kendrick and defendant Stillwell said to him the things he said in the 2015 interview.
Right.
But now he's proffering theories about their actual involvement. He said, yes, they said that. They did say it. And when Detective Dennis says, after Mr. Zachary gives him a rendition of events, and Detective Dennis says Yak said something different, there's nothing about him meeting, and the argument could be made by the defense. You heard Mr. Kendrick or whomever wants to make the argument, but that is a piece of evidence that will be put in at trial at the appropriate time. So
A piece of evidence being
Mr. Kendrick's,
statement where he does in fact say something different.
yes,
What you're
about
saying?
himself.
Okay.
So
And he's already made whatever that statement is by the time of this 2017 interview with Mr. Zachary.
he has.
Okay, and so whether Investigator Dennis talked to Mr. Kendrick himself or not, Mr. Dennis is aware that in fact, Yak did say something different.
Right. He's
Okay.
saying, right. He's,
And does,
and it's a broad.
does Mr. Kendrick's interview, when we get to the top of page 116, Investigator Dennis is saying, Yak said he was on his way to his girlfriend's house, I guess.
He does say that.
Okay. All right, and so,
Your Honor, that
yeah,
I don't believe that's an I know why you're asking that question, and in the spirit that you're asking the question, I don't believe that's an accurate answer. Mr. Kendrick, first of all, a couple of things. My understanding, Mr. Kendrick's statement has been suppressed.
oh,
No,
I don't think it's coming in.
she says no.
Judge,
Y'all,
the portion of the statement that it contains what we're discussing was not. What was suppressed is a portion where another detective comes in and starts talking to Mr. Kendrick.
okay,
So there's a very long part of the interview.
before the part that is
Yes.
suppressed, and it's in the unsuppressed part that the representations that you
Yes.
just made are contained.
I don't. Investigator Dennis on 116 line 8 says Yak said he was on his way to Bush's house.
Yeah.
And they saw Nut at the barber shop and they made the call. I don't know if Mr. Kendrick's saying that to any law enforcement.
Well, we ought to be able to check that. I mean, right, like the statement is,
And the made the call portion, I'll agree. That part he didn't say, but the part about him being on the way to Bush's house, which is what I think is the most.
No, and he didn't say he saw Nut at the barber shop. My recollection of the statement, and Mr. Weinstein's most on top of what was said in that interview and what portions were suppressed, but he said, I did not have anything to do with this killing. I went to my girlfriend's house. That's my alibi. I don't know. So the state, yes, he said he was with Busha in a car with her going to her house. He never said seeing Nut at the barbershop and making a call. That was not stated. So that's a misrepresentation of Mr. Kendrick's statement, first of all. And secondly, I mean, it's just completely confusing to the jurors.
okay,
So, Your Honor, the state's response to that is, when I stated there's information that Mr. Zachary and Detective Dennis exchanged before we reached the point where he says, that's not what Yak says.
yeah,
And the reason that is important is that there's a compound sort of statement at the top of 116, and Mr. Sharp is correct regarding Mr. Kendrick not saying we made the call, but the part where he says he was on his way to Bush's house.
right, that's not the part of the issue, it's
Right.
and they saw Nut at the barber shop. Does Mr. Kendrick in his statement say anything about seeing Nut at the barber shop?
My memory is that he doesn't say they saw Nut at the barber shop.
Okay,
My memory is that he doesn't say that they saw Nut at the barber shop,
okay, and
but that
That's-
he was on his way to Bush. So I'm not
That-
disputing that
don't-
part.
okay, so then that part needs, I would think, to be redacted out because it is confusing.
I have no problem with that. I just wanted the court to be aware of why, of the argument that we were making.
Okay.
So if the statement is going to be introduced as evidence, the reason that we were not conceding that part is that Detective Dennis's.
That part's fine. I understand everybody's arguments. So let's get to what we are redacting out.
Yes, Your Honor.
So page 116, line 9, and they saw nut at the barber shop. Frankly, why don't you just also skip line 10 and line 11?
Okay.
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 Does that satisfy your objection, Mr.
Yes, Your Honor.
Short? Okay.
Yes, Your Honor.
Oh, yeah.
Next one is on 117. No, what I'm looking at is number 40, which is what, oh, yes, on the other one, no, 9. Going back to number 39. The Yak said he was on the way to Busha House is fine. So the part that says, and they saw nut at the barber shop, that part of 9 and then all of 10 and 11. Okay.
And just to clarify, Detective Dennis was one of the 3 in that interview.
Okay. Thank you. All right, as to the next one, Mr. Sharp, your objection is to in the investigator's statement, right? Or also the answer?
It's the investigator's statement, and I don't necessarily have a problem to the extent that he's asking Mr. Zachary a question.
Mm-hmm.
I don't think it's appropriate for him to say, see, that's, I know sat through so many interviews, heard so many different stories, kind of pieced
Right.
together by time dates.
In time frame. Okay, so.
You said poach holes in everybody's story.
So, I would think maybe to avert that issue, can we consider a redaction from 117 lines 23 through 25? And then just start with 118 line 1, beginning with everything you just said, pokes holes in everybody's story, because then Zachary says, yeah, you know, it does poke some holes. Because you don't seem to be objecting to the answer.
I would suggest starting on 118 line 2.
Okay, that's fine. Well, oh, like 3 or 4 or 5 is the answer. Okay, I thought he was saying this is the number of holes it might poke. Okay, yeah, no, that makes more sense. Okay. So, 118. Okay, so redact by agreement then, 117 line 22 through 118 line 2, the word story, and just pick back up with because of Deamonte. All right. Okay.
Could you please pull your mic back? Thank you.
Closer to me or further from me? Yes, ma'am.
Closer so we can hear you. All right.
Are we on 118?
All right, why do you? All right, so the objection as to the 41 is that it's speculation. Is that right?
Right. It's a hypothetical. If it did, I'm reading that if they did it, I don't think Deamonte had anything to do with it. Why he ain't take it like you said, look at me and like little brother. I think in context, what he's articulating is people look at him as a little brother. And I mean, he wasn't there. He's not offering firsthand knowledge. He's just giving his theory that I don't think Deamonte would be involved with
Okay.
something like that if they did it. And I just think that's
Okay.
speculation.
Does the state want to respond?
In as much as this is something that is repeated throughout Mr. Zachary's interview, and in as much as there is information that Deamonte gave to Mr. Zachary, similar to the way that he gave information to another witness in this case who now understand. The reason that I believe that this should remain in is that Mr. Zachary, at one point, Mr. Garlington was charged, but not by the state. And Mr. Zachary was in a position, he was with Mr. Garlington, Mr. Kendrick, and Mr. Stillwell after the murder, following the murder. So in as much as he makes the assertion, he later says more stuff like, Deamonte never told me that he did it. He talks about what each person said to him. But I'll defer to the court. It's just, that's the reason that I wasn't asking or conceding immediately
right.
that come out.
I mean, that seems like a valid objection. So we're going to strike 118.24 through 119 line 5. I'm sorry, line 4. This one. Share. All right, and this is the witness, Zachary, relating what Deamonte has told him. And the objection is hearsay. What's the state's response?
Okay, I'm going to Deamonte's statements to Mr. Garlington, I'm sorry, to Mr. Zachary. Much like the statements that Mr. Garlington made to Mr. Copeland are statements of a co-conspirator. Later in the interview, Mr. Zachary expressly said, essentially, it was a matter of keeping us all in the loop, the information that was exchanged. At one point, he's asked, why are you all talking for 30 minutes at the condo after the murder if nobody knows anything about it? And if not to that specific question later on, Mr. Zachary says something to the effect of, we're just trying to keep each other in the loop so that we all know what's going on. In other words, from the way that I would argue it, Nut just got killed. Stuff, you know, we have to keep ourselves.
Okay, so that would certainly make sense with regard to anything that got told to other alleged members of the gang right afterwards at the condo. As to this particular statement, Zachary actually gets asked, when did he tell you about that while y'all been locked down? And Zachary says, yeah, well, I've been locked up. So when was that? When did they get locked up?
So in the latter part of 2015.
Okay, and so if that is when this story gets shared.
So during that time, other evidence will show that as a result of the murder of Diamond Thomas, there were conflicts that existed both in to answer the court's, but I think the question is
Yeah.
how does it keep them safe? So the conspiracy that exists after Diamond Thomas is killed and before Diamond Thomas is killed doesn't stop when they get locked up. Inside the jail, there are conflicts as a result of the Diamond Thomas murder, and the knowledge or belief by members of if gang that YSL is the entity responsible, or people within YSL are responsible. So the fact that Mr. Garlington is sharing with Mr. Zachary events that happened, I would argue still fall within the co-conspirator exception, or it still makes it admissible as a co-conspirator statement, but it's not something I'll hang a hat on and the court sees it differently than just 1 second. It's not one that I'm going to strongly object to. It's just, so it is a co-conspirator statement. These statements within the rest of the interview that are very similar to this are all co-conspirator statements. And for that reason, object to the co-conspirator statements coming out. I'll just leave it at that. And of course, it's not one that I'm going to, I'll defer to the court's decision, whatever it is. I'd argue that it is a co-conspirator statement, but there are more statements similar to this made by Mr. Garlington to Mr. Zachary that he alludes to. So I'm going to be making a similar argument about other statements like this. And for that reason, I'm not going to object strenuously to this particular one coming out. Object strenuously.
All right, so late 2015, are there?
Can I give Your Honor a little context?
Yeah.
So Mr. Garlington and 3 other individuals, I believe it was 3 other individuals, including my client, Mr. Stillwell, warrants were taken out for them in around October of 2015, based on the testimony or the word of a gentleman named Nicholas Robinson, or Spencer Wright, depending on when you ask him. But he gave these statements to police. They went and investigator Thorpe went and got warrants for these gentlemen. On subsequent review of the footage from the scene, Nicholas Robinson was not present where he claimed to be on the scene. So at the time of giving these statements, Mr. Garlington, and there's jail calls that I believe reflect this, Mr. Garlington is in extreme prove my innocence, shift blame mode. He's not in any sort of co-conspirator, we're in this together mode. And he is asserting to anyone and everyone that will listen is, I didn't have anything to do with this. I'm wrongfully arrested. He's asking people to get video from the McDonald's on Cleveland Avenue, video that we still don't have, that will show he's innocent.
Right.
And so these conversations that Quindarius Zachary is saying Mr. Garlington had with him are, from my perspective, for the purpose of asserting his innocence and shifting blame to others. So that would not fall under 801 D2E.
All right, and that's sort of what I'm trying to sort out is this a time that is, when this is shared in furtherance of the conspiracy, or is it not? And if there are, in fact, still beefs going on inside of the jail or outside, I mean, do they get released after late 2015?
No, it dies down a lot.
No, sorry. I just asked a compound question. So I am wondering about what is the state of the beef back and forth. And then I'm also wondering, do Zachary and Garlington get released after they're locked up in late 2015?
No. So
Okay.
they get released at some point later, much later. For instance, Zachary gets prison time, Garlington also.
Right. Okay. But not at a point in time when like they might be out in a week. And so they need to know what's going on the street. So they all need to.
Well, not on the streets.
Okay. So tell me, is there in the jails beefs back and forth where they all need to be on the same page about something? Tell me, how is this in furtherance of the conspiracy?
So while they are in the jail, and this is broadly speaking, and not to this, at this point in time, while they are in the jail, inclusive of this point in time, there are continued, there are statements made and conversations that are had about different YSL members getting beaten up by IF gang members. So there's evidence that we have to show of a continuing conflict within the jail and within.
Okay. How does Mr. Garlington telling Mr. Zachary, I wasn't involved, in furtherance of the conspiracy? Well, and the Woody picked me up after the shooting. I mean, because that's really the thing that he says. How does that further the conspiracy?
Our argument is that it fosters cohesiveness. It is information shared between two YSL members while they are in the same predicament of being confined among other persons who are members of an opposition.
All right. So, I mean, I think the fact that on at 122 page 122, lines 1 through 3, the answer being that Garlington said, no, he does not. He says that Woody picked him up after the shooting. That's not, hey, Betty, I've got absolutely zero to do with this. It is still something that could in some way be against his penal interest. So I am going to find that to meet that co-conspirator exception. So I'm going to overrule the objection on that one.
So it just So we're playing from 1 to 3 on 8.12.
Yes.
Okay. Okay, meaning I understand the court rule.
Yeah, no, I understand. I understand. But yes, that's probably a good idea to clarify that for the record. All right, so moving to number 43, which starts at the beginning of page 124 and is most of that page. All right, what does the state say about this one?
So, Your Honor, in order for the argument is that it's hearsay about what the Meghann said, and
Is that the argument or is the argument here? I mean, at least what's on the, yeah, false hearsay, if you will.
I'm sorry, I was looking at 42, 43.
Yeah. Yeah.
Was my impression, and really for my notes, the fact that whether it was truly what Meghann said or not truly what Meghann said, the falsity is irrelevant. I take exception to Investigator Dennis relaying in a statement that would be heard by the jury what Deamonte Garlington supposedly said to him. Deamonte Garlington is not going to take the stand, to my understanding, in this case.
All right. Is Deamonte Garlington's statement going to come in?
No, his statement to law enforcement will not come in. And we won't
Okay.
call it. And for that reason, I don't object to 1 through 4 on page 24, but when we get into, again, Zachary talking about what was shared to him by Mr. Garlington, we would object to that portion, but I don't have an objection to 1 through 4. The numbers 1 through 4, but the objection, the redaction requested is 1 through 22, so I'm prepared to argue the rest of it. So in as much as the argument made just now by Mr. Shard is his objection is to Detective Dennis relaying what Garlington said, there's no objection to that portion.
Okay. Okay, so you're saying 5 through 22 is essentially just questioning. It's not any true or false assertion of what Garlington said. It's just him asking questions and Zachary answering them, right?
So it is sort of, it's him. So there was one thing, and I'm sorry, I apologize for doing this. It is much as Mr. Zachary acknowledges knowing that the police talked to Deamonte Garlington. And in as much as that is contained within 1 through 3, I'd ask that the court keep that in and allow me to change that portion of my previous representation to the.
Okay, is there gonna, well, what about, then what are we doing about line 4?
That that's the part that I believe is not proper. I think that's a testimonial statement that
Okay, so then let me go back to Mr. Shart. If 4 is redacted out, then what is your objection to the rest of it?
I don't have an objection to 1 and 3. I do, so to the extent that these are being brought in for Quamarvious Zachary's answers,
Yeah,
and this is gonna bleed into number 44 on my list.
okay.
It goes into, my understanding is this information Quamarvious Zachary is giving investigator Dennis is based on things Deamonte Garlington, it's being asserted that Deamonte Garlington told Zachary in the jail when Garlington was trying to proclaim his innocence.
Okay.
So that is, I don't feel that these answers
Mm-hmm.
fall under the 801 D2E because again, I don't feel that they're in furtherance of a conspiracy, the statements made in the jail. So that would be my objection to the answers.
Okay.
And those are interspersed in what I objected to in number 43 and then specifically in 44 as well.
Okay.
hang on, my perspective on that, for the reasons that I've already shared, are different than Mr. Sharp's. And I would add to what I've already said, that in considering, if it even comes to playing it, in considering what Mr. Zachary is telling you and making a determination about whether the tape is true or not, Mr. Zachary at line 23, when challenged, essentially Detective Dennis is challenging him about what he has said in line 13 through 16. He says, as what's reflected in the transcript, Zachary pushes back, and then Dennis is asking another set of questions, and Zachary is correcting Dennis with information that he got from Garlington, again, still during this time when they are in confinement, and still during a time when there is still beef, if you will, between the two groups, YSL and FK. So to the extent that Garlington may want to get out of jail, I'm not understanding there to be any argument that Garlington is somehow an agent or another, just that Garlington wants to get out of jail. And somehow that makes this not a co-conspirator statement.
Right, that he's no longer saying anything. He's saying about, here's what happened, Zachary. Hey, Zachary, here's what happened. Because you're my fellow gang member and you need to know this. He's saying, I am innocent of all of this in the hope that either, I don't know whether he cares whether Zachary believes it or not, but in hopes that that gets out.
And my position is that would be an argument to be made. Obviously, the jury can take what they hear and do it.
Okay, but I have to make an evidentiary determination whether this is a statement made in furtherance of the conspiracy, which is what we're discussing.
And our position is that it is for the reasons that we've given to the court.
All right, I'm gonna allow it. And that would be what you cover in your item number 43. And then what I've looked at right now is the first part of your 44, which is through page 125, line 15. It looks like then there's a second set of facts. So I hadn't looked at that or made a ruling about that yet. So,
I understand.
okay.
And we can get to that if Your Honor would like to, because number 45, I'm going to withdraw.
Okay.
So that puts us back at the second part of 44.
Okay. All right. So the second part of 44 is on page 126, well, all of 126 and then half of 127. So let me take a look at that real fast and then is it the same argument as to this also?
Yes, Your Honor.
Okay, let me just take a look at it. All right, let me ask you, on page 126, lines 15 through 18, seems like there might be a separate objection to that little part. Or you had withdrawn the gun part anyway?
I understand, Your Honor. He says that's
If you don't care, I don't care
well, he says
either.
that's what I assume, and then he says that's what I heard. The source, I wasn't going.
So, if it
we
doesn't,
assume that the source of that's what I heard is Deamonte Garlington, it would fall under the same.
okay. All right, I just wanted to make sure.
I'll just point out at the bottom of 126, I think Investigator Dennis agrees with my view on these statements. That it's people putting their own version of their defense to try to say that they weren't involved. And that's the point I guess I'm trying to make.
So I suspect we'll see that on a slide during your closing argument. All right, yeah, no, my ruling is the same with regard to item 46. So that is in. All right, that takes us to 47, which is on 129. I'm not sure I follow your objection. To 140, to your item number. Oh, wait a minute. Yeah, I'm sorry. 47. Your item number 47, 129, 1 through 14.
46, I thought we were on. But I will withdraw 46.
Okay. Okay, so now to 47. It says speculation about getting rid of guns, but the speculation about getting rid of guns seems to occur sort of after line 14. And your objection was to lines 1 through 14.
I agree, Your Honor, and I'm going to withdraw number 47
All right.
as well.
All right, so moving to item 48 on page 140.
I'll withdraw that one.
All right, seems to help you. All right, 141, line 11 through first part of 142. And is there your objection that the questions by the investigator are based on hearsay?
The questions are based on hearsay. You know, he's declaring, Investigator Dennis, I mean, they're inviting responses, I guess, but they're kind of more statements. He's saying that basically my client is involved in a list of shootings, and then he eventually lists them. One of them, I think we already discussed, Lucci's Mama House is the words he uses. We already discussed that I believe we already discussed that was based on what Mr. Zachary told him, which was based on hearsay. He wasn't there. So it's just based on rumors. He's just recapping what Zachary said, and what Zachary said has already been ruled coming out is my recollection. So Lucci's Mama House, he said he did the bus. We've already established that Mr. Zachary wasn't present at the shooting of the bus. So Mr. Zachary wasn't allowed to talk about, or we're not going to play what Mr. Zachary said regarding who did the shooting. But so I don't know why we would allow Investigator Dennis to repeat it. And then the murder, I mean, that's a question for the jury here. And I understand that there's certain things that are helpful. Mr. Zachary says, I don't think he did the murder. I would like that to come in, but not in the context of Investigator Dennis listing a bunch of other shootings that are on this indictment that he's concluded my client has done.
With whom?
Right.
So if we're talking about page 141, starting at line 11, from what I'm hearing, there is no objection to No, he does object to it. Okay, I see what he said. Your Honor, Mr. Zachary he's conveying something about Mr. Stillwell, at least his current iteration of events about Mr. Stillwell. He's saying he wasn't in a lot of shootings and stuff.
Right.
Dennis is saying essentially, what, really? And Zachary is reiterating the point. And then Dennis is asking for clarification. When Zachary says it's probably so many shootings,
Uh-huh.
and then later on he says they go all the way back to 2014. He's clarifying information he's giving to Dennis, and he is giving information that we would argue he does have a basis for knowing. I don't have a problem taking out he did the bust, the murder. But the three biggest ones from lines 6 through 7, we would argue that those are events or incidents which Mr. Garlington does have information about.
Okay, so I think that (141) lines 11 through 25 are okay.
Can I state my specific objection to that?
Yeah.
Okay, so my specific, on 11 to 25 on page 141, what I'm specifically objecting to is when Investigator Dennis says,
Can you pick up your mic? I'm sorry. I know that's kind of annoying, but
no, it's fine. He says, right, and he just basically was, from what I've gathered in basically interviewing people and him, again, I don't know when Investigator Dennis, to my information and belief, only spoke to Mr. Stillwell as a victim in a case where a young woman was killed back in 2015. So I don't know where "and him" comes from. He was quiet until it was time for some action, and then it was almost like sick him.
okay.
So he's like basically saying my client is, a leash pit bull.
Okay. All right. Okay. So then let's strike that question 11 through 14 because it's really not, it kind of interjects. And if you went straight from Zachary talking his answer from 7 to 10 and then pick up with what he continues to say 15 to 17, I mean, that works just as well. So, and you're nodding, Miss Love, you agree?
Yes.
Okay. So 11 through 14 are redacted by agreement on page 141. And then 15 through 25 of that page, I'm going to permit in. And then,
So
yeah.
my issue with 142 is Investigator Dennis says,
Yeah, now I'm getting to
Okay.
that.
Okay,
getting
I'm
to that.
sorry.
And maybe you'll be satisfied.
all right,
I don't know, but whether you are or not, this is my thought at this point is 15 through 25 are in, and then redact on page 142, 1 through 8, and pick up with line 9. And that avoids all of the Dennis saying something about a shooting that okay, does that work for you, Miss Love?
Yeah.
So Miss Love agrees to that. So Mr. Shart, I
That
want to
works.
make sure that, so that, do you have any further commentary with regard after that ruling?
no, Your Honor.
Okay. All right, moving us to page 146.
Yeah.
Okay.
Judge, good morning. Keith Adams on
Good
behalf
morning.
of Mr. Williams. So this is number 50 on Mr. Shard's checklist.
Yep.
The entirety of this testimony and the context of it is that this is a conversation where Mr. Sprinkle's involved, the detectives are involved, and they're talking to Mr. Zachary about what they believe to be a beef, for lack of a better word, between Mr. Williams and DeQuantis Lamar, gentleman
Right.
known as Rich Homie Quan. In short, my objection for this entire segment of the conversation, starting at 146, line 20, going all the way to 149.3, is that a speculation? If you read through it, Mr. Zachary is opining about the reason that, well, first he's opining that there's a beef, in fact, a beef between Mr. Williams and Mr. Lamar. And he opines as to what the reasons are.
Right.
The detectives are kind of interjecting their own take on what has happened and why they fell out. And if the most telling part is if you look at page 149, towards the end of that, and it really kind of starts in the end of 148, where Mr. Zachary's talking about how Mr. Lamar and Mr. Williams fell out, and Birdman, a Rich Homie, fell out for some reason. I don't know, he says, continues on to page 149, where the investigator asks him because he wouldn't sign. And then Mr. Zachary says, I don't know, I guess. That kind of encapsulates the fact that most of what he's talking about is what he's heard, what may be on the street. And there's no real basis where that speculation is coming from. So I'd ask that all of that be kept out because it's just speculative.
All right. Well, I think that you're right with regard to the very end of 148, top of 149 about, Birdman and Rich Homie having fallen out, and, the reason that might have happened being speculation on the part of Zachary. But that's kind of a separate topic from everything that they're talking about before.
Well, if you look at the entire, even starting back at 146 and going through, there are portions, for example, let's look at 148, the top of 148, line 1, where Mr. Zachary says something to the effect of, and Rich Homie knew that they were shooting, that they had done shot up thug. There's no way that he would know what's in Mr. Lamar's mind, what he knew. There's nothing to indicate the basis of that knowledge. And I will say that Mr. Lamar is a state's witness. He's on the witness list. We've been noticed that he's potentially going to be called. Birdman is on the state's witness list. Mr. Brian Williams.
Right.
We've been noticed that he may potentially be called. And so these are witnesses that if the state intends to prove their theory. I'm going to say it's their theory that there was this beef between Mr. Williams and Mr. Lamar, and that's relevant in some form or fashion. They have witnesses that they can call to do that.
All right, but you know, they can corroborate their own witness testimony with something else if they got something else. So that's not an evidentiary objection. That may just be wishful thinking.
Well, yeah, I don't know if they're going to call those witnesses.
I don't either.
And if they want to corroborate, if they call them and they want to corroborate it, then they can say perhaps that Mrs. Zachary knew this in some form or fashion, heard it from those witnesses, but there's no indication that this is anything other than speculation on the part of Mr. Zachary.
All right, Ms. Love.
So, Your Honor, I think some context is necessary here. There have been repeated attempts by Mr. Williams to rebut evidence the state believes has shown that Mr. Lamar and he fell out after Donovan Thomas's murder.
Okay.
Donovan Thomas's father was one of our witnesses, and some of the questions on cross-examination involved defendant Williams showing photographs of Mr. Lamar and Mr. Williams together at times that were after, I believe after the shooting, if I'm remembering the exhibits correctly. There were Instagram posts and things of that nature, a video of Mr. Lamar and Mr. Williams, a music video of them that they both appeared in.
Yeah.
And that was after specific questions regarding Mr. Lamar's continued association with Mr. Williams after Mr. Thomas's death.
Okay.
When ADA Sprinkle asks in line 18 through 19 of page 146, so what happened? Why weren't they working together anymore? The answer Mr. Zachary gives, his basis for knowing that information, or at least broadly that information, is contained within the statements that he gives just prior to that, when he's talking about having been on tour, being on tour with defendant Williams during this long period of time. So in line 9, when ADA Sprinkle asks, you know about Young Thug getting up on stage in March of 2015, calling Rich Homie Quan, bitch Homie Quan.
Mm-hmm.
And Mr. Zachary says, I was with him, yeah. And then ADA Sprinkle says, you weren't there? And Zachary says, I was with him when he said that.
Yeah.
So these statements provide a basis for Mr. Zachary's knowledge of whether or not defendant Williams and Mr. Lamar continued to work together.
Okay. And I mean, I notice on page 147, line 19, no, line 20, I mean, Mr. Zachary's saying, like, basically, I stay at the same place as Thug does in that apartment building too. So he's got a basis for knowing what he is saying on 146 and 147 and 148. Now, I'm agree that 149 starting at 23 is kind of a different topic in speculation. So I'm going to strike that, and the objection went through 149 line 3. That I'm going to strike, but
And-
just that. The rest of it.
Judge, I just wanted to make one correction regarding line 20 of page 147. So
Yeah.
it wasn't that reference was meant for Mr. Lamar, not, even though it says you have to listen to it.
Uh-huh.
I think it was he, I think.
Oh, okay.
That's correct.
All right, thank you.
That's correct. What
Appreciate
he
it.
is saying is that Rich Homie.
Okay,
stayed the same
well, it
bill.
says we, but I guess that's
It's-
either a typo or a mistranscription. Okay. All right, so then,
And,
what
but
is his basis then for knowing all of this?
I was about to say, but even with that, he's
Uh-huh.
describing he's describing later on how much time he spends in the condo. And I believe at one point he even talks about the fact that he went down on one occasion and let somebody in.
Okay.
When asked how do people get in, they were trying to ask him about a call box, but he's saying, I went and let them in. No. So he spends and talks about the amount of time he spends, a lot of time with Mr. Williams in that condo. So my argument is that he, throughout the interview, he gives a basis for that knowledge.
Okay.
The only thing that I'd follow up with on that, Judge, is that,
All right.
that's a different point, right? The fact that he knows Rich Homie Quan, the fact that he knows Jeffery Williams, the fact that he knows where someone lives, the fact that he went and let someone in does not give him the basis of knowledge of what is in someone's mind or why someone fell out. That's what the conversation is about.
All right. So, Ms. Love, what's your response to that?
So I would argue that his proximity with Mr. Williams and his association and relationship with Mr. Williams, as reflected in the fact that he's always at the condo, even on occasions when Mr. Williams is not there, is the basis for a knowledge of why they don't work together and a basis for his knowledge of what happened.
Okay. And you have evidence that establishes their close relationship at this period in time.
Yes, his
Okay.
words, Mr.
Okay.
Zachary's words throughout the interview
All right.
are
Then-
reflective of that.
Okay. Then I will stand on my prior ruling.
So just to be clear, Judge, what is the court saying will be kept out?
148, line 23 through 149, line 3. All right, we're at the bottom of 152 now. All right, Miss Love, why would this be in?
So we have already introduced the evidence of the Dexter Montgomery shooting. That's what this information is, starting at page 152, line 24. We have already introduced evidence that DK or Walter Murphy and Nard or Demise McMullen were the persons who committed the shooting that led to the victim's head being blown off, half of it. Mr. Zachary's assertions about who did that, I would argue, come from his relationship with members of YSL, with Walter Murphy and Demise McMullen, or other members of YSL. the portions where there is commentary by Detective Dennis, for instance, the part about page 153, lines 14 through 19, I don't have an objection
Right.
to. As well as lines 20 through 25, I don't have an objection to. Because those are not things that Quindary Zachary is telling Detective Dennis. That's Dennis.
Well, then how about 154, 1 through at least 14, but that's all just the investigators talking
At least 14.
about basically their own investigation.
I don't have any.
Frank, yeah.
So there's a portion where Mr. Zachary is, you see it on the video, he's looking at what they're showing him.
Mhm.
So where I don't have any problem with, for instance, 1 through 4, on page 154, I would ask that 5 through 17 be kept in, because that's the portion where he's
Looking at pictures.
right, either has just looked at pictures, and Dennis is now saying that right there is DK walking
Okay.
with an assault rifle.
All right. So
And-
that's 5 through 8.
Yes, 5 through 8.
Okay.
And as I think I just said it, but if I didn't, 9 through 14 is, I don't have any objection to that coming out.
Okay, but what about the rest of 154, basically? That's the investigators counting bodies. And
Part of-
all Zachary says is basically like, who are you talking about?
So I don't have any problem. I don't have any objection, rather, I'm sorry,
Okay.
to that coming out. And so that's from.
That's
3
basically
from 5
153 line 14 through 154 line 4, and then 154 line 9 through 24.
Yes, no objection.
All right, so let's circle back to 152 line 20. Through 153 line 13.
I don't have any objection to 153 lines 1 through 13. So I guess that's all of
All right.
153.
All right, so what about 152 17 to the bottom? Or 20, I'm sorry, 20 to the bottom. Although I think it's 17 to the bottom, because I think that's like the lead into.
It is. He's asking about the Dexter Montgomery shooting. I don't remember the exact words at 18, but it is.
Yeah.
I would argue that as to that,
I mean, I don't know, it may be significant to your case that he's even heard about it. So I don't know, you tell me.
well, that's the point that I was making earlier, was that it was his proximity and relationship with the other members of YSL that afford him the knowledge about Nard and DK doing it. And we have shown evidence that Nard and DK did it. So we would
Okay.
object to that part coming.
All right, so 20 through 22 essentially then, or 17 through 22, you're saying that shows, although it doesn't show the basis, who he heard it from, but
It doesn't, but if us with the
all coupled together would show he heard it from.
other members of.
Okay, so, I mean, I think that then, could be relevant to the state's case, and you're offering it there to show he heard about it and that they kept each other connected. So that I will leave in. But what'd you hear about it? 23 and 24 out.
No, 24, he says, you can't see it on here, but on the tape, I can give you the timestamp. He says, they say DK and Nard did it.
Okay. Okay.
I just don't understand how that's not hearsay.
It is hearsay. It's hearsay that is being permitted under the co-conspirator exception.
Who I would ask the state who, if I'm permitted by the court, who told him this?
So as I understand Miss Love's representations to the court are that fellow members of the gang told him. Is that right, Ms. Love?
The basis for his having that knowledge would be his proximity and relationship and association with other YSL members. What I said when I first spoke on this is we would not ask for rank hearsay. We would establish a foundation. And if we don't establish a foundation, if we don't establish that it was a member of YSL, like if he's just like the streets talk, then we would not ask who did it or do you hear who did it and then try to impeach him with what he said.
Okay, so essentially, as long as she lays that foundation, that's the basis of the witness's knowledge.
And just moving forward, and because I don't know the answer to this question, but I do know that Mr. DK is Mr. Murphy, Nard is Mr. McMullen. They were arrested and charged for this event. They may have already been arrested by the time they're having this conversation. I don't know the answer to that. But I just think that there's a lot of different ways that Mr. Zachary could come to that conclusion other than a co-conspirator statement. And I just want to be clear, we are putting, if they don't establish a foundation, should this tape be played, the ball is in their court to make sure all this is taken out.
Correct? All right, you clear about that? Yes. Okay, so make sure that foundation is laid before, to the extent you end up needing to play this, that you have laid that foundation before you play it.
That is what I understand the purpose of this exercise.
All right, so we're clear then, assuming that foundation, 152, 17 through 24 come in, 153, all of 153 and 154 are out by agreement. And we hadn't kind of picked apart 155 and the top of 156 yet.
Did you say all of 154 or?
Yeah, that seems to be what you ultimately agreed to.
5 through 8.
Oh, right. I'm sorry. With the exception of 5 through 8. Thank you. Sorry. You're right. All right, so how about 155?
I don't have any objection to 155.
All right, 155 is redacted by agreement. And then the top of 156, 1 through 6.
So
Next item is 157, 1 through 22.
So our argument is that it's co-conspirators statements. And I don't know if the court wants to hear from Mr. Sharp first. So if the court does, I'll just wait. But our argument is that we would object to this coming out because Mr. Zachary is asked on the previous page, page 156 at line 7, about his prior statement.
Right.
And as I said earlier, what he's doing within this statement is he's acknowledging that he said it. He's maintaining what he told them in the 2015 interview regarding what 2 of the defendants on trial now said to him. But he is qualifying it and asserting, maybe they did. Acknowledging they said that they did, but offering as well his opinion. I don't believe they really did it though. And so when Mr. Bailey at line 7 on page 156, what he's asking him that is listed on the transcript as indiscernible is the first time that you talked to Dennis and Gaither, what did you tell them about Shannon? And Mr. Zachary just sort of says, yeah, and Mr. Bailey asks him again. I think a couple of times.
Mm-hmm.
And then at line 17 on page 156, he's talking about that he says, in line 15 and 16, Mr. Bailey says, what did you say they told you? And in response, it's listed as indiscernible, but that's what he's asking. What did you tell investigators that they told you? And in 17 and 18, Mr. Zachary is saying that they shot at Nut, but later on, he told me he didn't do it though. So we'd argue that one, there's a reason we would want to play that part and into page 157, because now everybody sort of knows that there's a statement and people are talking, people are telling on members of YSL. There's communication in jail calls and in other places reflecting members of YSL sort of incredulity, their, like dismay at the fact that various people are telling.
Mm-hmm.
I think at some point there's a definite call that Lil D, and that's when Darius Zachary is called Lil D. Demekion Garlington is also called Lil D, but there is a jail call where they say Lil D told or Lil D is telling. And Mr. Zachary, now being aware that people know he gave that August 2015 statement, is trying to pull back So we want to play it to show evidence of the enterprise itself, how it operates, what happens when people tell, and how people react. All of that, we argue that it's relevant evidence and not just hearsay.
Okay.
Well, that is a way to bootstrap hearsay, to say we want to play the hearsay to show the way people react to someone saying the hearsay. But my objection is 157 line 1 to 22. And I'll just say, Ms. Love just keeps saying, Quamarvious Zachary is saying what they say, or they said. On 157 line 7, in my notes, Quamarvious Zachary it says no, and then indiscernible. What indiscernible is Deamonte says. Deamonte says that they were all in the car. They were all in the car. In what car? In they rental car is what it says on the tape. So he's repeating what Deamonte Garlington told him in the jail while he's trying to assert his innocence. And Deamonte is putting himself out as being dropped off outside the car and putting Deamonte and then eventually putting Shannon, Mr. Kendricks, Mr. McMullen, and Mr. Cobb in the car. So it goes back to the same argument that I'm making, and I know Your Honor hasn't necessarily agreed with me in the past, but I still have to make the argument that these were statements that Deamonte Garlington is strategically giving to Mr. Zachary, not to further any conspiracy, but to get out of jail. And he's trying to put his narrative out there, and that falls under, we've provided the cases to the court previously, Stafford, Wilkins, and there's two others, but it's spilling the beans, and there's one of those cases that I've given specifically that had to do with shifting blame. And he's shifting blame, and that's just does not fall, and my argument is that does not fall under 801D to E.
Your Honor, my interpretation of page 157 at least lines 1. My interpretation of it is that they are talking about up to a point at the very least, something that Shannon said. I don't disagree that it bleeds into comments about Deamonte Garlington, and I'd ask for the court with respect to the finer points to give me 1 second. So in the 2015 interview, Mr. Zachary tells police, and we'll get to that when we address those redactions. He tells the police that he doesn't know what in the world made them do that. And he was asked by Detective Gaither, made what do that? And Mr. Zachary says, people who killed him, Shannon, Yak, Nard. And then Detective Gaither says, Nard in jail for kidnapping. Mr. Zachary says, yeah, and Duop. He's then asked what Duop looks like. Then Detective Gaither says, how do you know this? Mr. Zachary says, because they told me. Detective Gaither says, who told you? In August 2015, Quamarvious Zachary says, Shannon and Yak told me. Detective Gaither says, why did they tell you that? Mr. Zachary says, we were at the house talking about it. Detective Gaither says, which house? Mr. Zachary says, Thug's house. Question, new or old? Mr. Zachary says, the old one, his condo down there. Detective Gaither says, exactly what did they say? And then from there, Mr. Zachary goes into a recitation of events that he says he got from Shannon
Okay.
and Yak. So the argument that this information came from Deamonte Garlington, who was just trying to clear his own name,
Right.
is belied, I think, by the information that the court will hear Mr. Zachary give in 2015.
Okay.
In your honor, I
Yes.
don't dispute that Mr. Zachary has said that Mr. Stillwell, that he's claimed that Mr. Stillwell and Mr. Kendricks made statements to him. That's not the point. And when we deal with those statements, we can address, we'll address those statements in the arguments. But in this particular statement, and we can listen to the tape, my notes say on line 7, Deamonte says that they were all in the car. They were all in the car. This information that we're dealing with right now, the source out of Mr. Zachary's own mouth, is the source is Deamonte. And that's what's on the table before us right now.
All right. So if we go back to 156 line 7, which is where this objection, I think, begins. No, it doesn't. But no, it doesn't. But if we go back there, at that point, they're talking about what Zachary told them way back in 2015, the source of which was the conversations amongst people at Mr. Williams' old Midtown condo. So close in time to the murder. And so y'all seem to know what a lot of the indiscernibles say. So on 156 at around line 16, I mean, they're talking about what did you tell them about Shannon? And then line 17, what's line 16 say? Do we know?
I'll tell you.
I can pull that up.
I'll tell you right now. On line 15 to 16, Charlie Bailey says in that interview, what did you say Shannon said?
Okay.
So that clarifies that portion.
Okay.
Read that.
So,
And Your Honor, it's only 1 minute from line 13 on page 1 or line 14 on page 156 to line 8 on page 157. So there are short intervals between them if there is a point at which we can play anything that helps clarify things.
And I understand that, but in that short interval, he switches to say Deamonte says that it was all in the car. So I mean, it does. He switches the declarant, and that doesn't take much time to do, and that's what he did in this conversation.
Because I don't.
so I don't know who is, I see that it says Deamonte told Shannon, but then it says Shannon didn't do it. He's saying they was in the car though. That he could be, who knows? That could be either of them.
I can't speak to that.
He said they was in the car when it happened, but they didn't see nothing. So I don't know what the basis for that.
Well, and that's Investigator Underwood talking at that point. So I don't know. Investigator Underwood's statement doesn't make a lot of sense in that context to me now, but I believe that the transcript is accurate.
So in 2015, during this first statement, does Zachary say that Shannon Stillwell maintained that he was in the car?
He says, he says that, but in a more, even a more.
Okay. And then does he also at that point before say that Garlington was in the car, at least in the car?
You're talking about the 2005, the early 2000,
Yeah.
earlier statement?
Mm-hmm.
He says,
So not,
go ahead. I'm sorry.
not in the car that.
In either of the two cars.
So in a car, but not the car that is doing the kill.
Right.
Shooting.
Okay. But this, whether it was Garlington or Shannon saying that they were in the car, but not that car. In 2015, when Zachary talked to law enforcement, did he at that point as well say that both Shannon and Garlington were in the car, a car, one of the two cars?
Yes.
Okay. So then I don't think it really matters who the he is there, because he's already said that. So that can't be based only on now Garlington saying some other story to get out of it. So I think 156 lines, well, y'all don't have an issue with that, but 157, 1-3 seems fine because he has a basis for knowing that is from before. And when we get down to 7, are you saying that now that answer that I think Deamonte said that they was all in the car?
Correct. He said, no, the quote that I have in my notes from this statement is, no, Deamonte says that they was all in the car. They was all in the car. And then investigator Underwood says, in what car? When Darius Zachary says, in they car, they rental car.
Right.
And then Underwood says, when it happened, well, and the rest is as described in the transcript.
Okay. I mean, none of that is Deamonte saying anything that really is like, I was in no way involved in this.
Well, my understanding of what Deamonte's saying, and just to
Is
add
that
context.
I was involved with all of it up until the point when conveniently I got dropped off.
Right.
Right.
My understanding of what the story is Deamonte's in the car. They're riding down the street. He gets dropped off. People switch cars.
Mhm.
And then he says who was in the car ultimately when it pulled off. And he wasn't in the car at that point.
And Your Honor, the information that Mr. Zachary shares in 2015, he says that he got that night or the next day. So he got before Mr. Garlington was ever arrested. So to the extent that the argument is, well, at least partially what I understand it to be regarding Mr. Garlington, the information that's being shared is information that Mr. Zachary previously asserted came from his conversations with defendants Kendrick and Stillwell.
Okay. I'm going to allow 156 line 7 through 157 line 22.
And can I just ask one thing?
Sure.
I don't want to disagree with Ms. Love about her characterization of what Zachary says Garlington said to him before, because quite honestly, I don't remember until we go over the transcript. But if in fact that transcript from 2015, earlier 2015, does not reveal that Garlington gave him information at that time, could we revisit
Sure.
And I was saying, and if I said I said Kendrick and Stillwell.
Yeah.
Well, right, we know, but Kendrick and Stillwell, we know that, but it seems to me that Miss Love is asserting that in 2015, Zachary is claiming that Garlington had already given him information prior to Garlington being arrested. And I don't know that to be true.
I don't know that that's what she was saying. Because what I had asked her was did he already have a basis for knowing all of that back?
He didn't. Mr. Stillwell and Mr. Kendricks allegedly gave Mr. Zachary information.
Mm-hmm.
I'm not going to agree that all of this information is included in that information. My stance, my belief is that this is information that was given by Mr. Garlington while he was incarcerated, which affects the analysis of the co-conspirator statement. And I don't believe it. And I understood the state's, and if that's not the state's argument, I understood the state's argument as, well, Zachary in his earlier statement had said that Garlington had already given him the information. And I don't know that to be true.
I don't think that's what she said, actually. But what I'm saying is, Mr. Garlington may think that if he puts a story out there that he was with all of the people alleged to have committed this crime as parties to a crime up until, 2 minutes beforehand, hops out and then gets picked up 2 minutes later, that gets him off the hook. That's wishful thinking, although apparently, I don't know. Anyway, I think he is still inculpating himself to me. So I guess I'm saying I understand, but reject your argument that this is, even if said during the jail stage, is at a point where it is no longer in furtherance of the conspiracy. I'm also saying it appears that Zachary had all of this information the first time around also.
Okay, that's the part I'm not
Okay.
necessarily.
And that may not be true, but if that changes, you can let me know. But my other ruling still is, adverse to your position.
Understood.
All right. But legitimately, we needed to get it cleared up. So, all right. So 158 lines 12 through 21. Actually, lunch is here. So why don't we break for lunch until, let's say 1:20.
And in searching through the discovery that has been turned over with respect to the representation that I made to the court about the number being on the wire, within the discovery that was served in 2022, the phone number that we've gotten the records for and the last name of Mr. Boyer is provided within the Sumlin Dorsey conspiracy. And I said wiretap. There are 2 wiretaps that were gotten. This name and this number appears in both, and the name for the number appears in the Sumlin wiretap.
All right, and you produced that to the defense as a part of the Sumlin Dorsey conspiracy package of discovery in 2022. Is that what you're saying?
Yes. You distilled that much
Okay.
better than I said it.
And do you have anything more specific than that to point out to show like exactly when that discovery got served?
I do. Hold on.
Okay.
Just need to know the date. The 2nd, 2022.
All right.
And the folder specifically that the number and the name appear in the discovery served August 2022, it's folder 1, counts in indictment by act. Act 181 through 182, Sumlin, Dorsey. Count 55, 181 through 182, discovery 2, Dorsey conspiracy. And it is the 6 call down,
Okay.
which has on it, and I will submit this as states 1 for the purposes of today.
Okay.
It has the phone number 470-957-2893 - Dorsey and Boyer.
All right. Okay, that appears to clear up that issue. Y'all can double check and make sure it's, says what she said it said. I don't know. Let's ask.
Can I pass them around or I'll give it to the court first?
Sure.
We just screenshot the tranche.
Okay, if y'all got a screenshot of it, maybe send that email around to everybody so they can see. But
And also we sent it a second time when we organized the discovery for the defendant. So it's in 2 different sets of discovery. The first one is from August 2022.
okay. I'm happy to pass that around at the time because she's got it highlighted. Y'all can all take a look at it, but she's going to email, or she or Mr. Atkins are going to email that as well. And then it sounds like it got reserved later in 2022. Thank you, Ms. Love, for digging through to figure that out. All right. And then do you have hands on the affidavit and search warrant yet?
I label it states 2.
Okay. I guess the court reporter is asking about the labeling. So yesterday we had a states 1 and 2, and we sort of had a motion, I guess, with regard to, I guess that was,
We labeled it differently. We labeled it States 1 Melnick proffer.
okay.
We labeled today's States Exhibit 1 as States Exhibit 1, August 7th, 2024, if that's today's date.
Okay, so it's weird, I guess, because I'm sure there are 100 million, I exaggerate, but a number of states exhibits that have already been in for the jury trial. We're sort of paused on the jury trial and kind of doing, we're doing motions in limine for the most part, really, sort of, but this isn't that either. This is, I don't know what to call this. Just don't know what to call this. Let's just say it, states 1 and 2 to the Boyer discovery matter.
Okay?
How about that?
Yes.
Okay.
Can we get a staple?
I've got some paper clips.
I think we know where it's secretly kept. And if not, it's simply,
I'm not stapler.
You want your arms?
A stapler?
it's fine.
That would be perfect, Ron. Thank
Gotta give it back to me.
you.
Yeah, come on up to the,
I'm not sure if anything's being cured or.
well, I don't know.
So let me first start off by saying that the discovery in this case, including, I call them dumps, whatever okay, 1 and 2 came together. And all the different additions, 3, 4, all the way up to, I think there was 13 or 12. They're divided by counts.
Okay.
Okay, so count 55, I believe.
Is the conspiracy
It's
that
a,
is connected to the drinks murder, right?
no, it's not.
No? Oh.
No, that's one thing. It's a conspiracy. It's count 55 in this
Oh.
indictment, which involves,
The murder of Harold Clements,
Well, he's not dead.
right?
well, that's not in this indictment. It involves,
What is
Oh,
in this
I'm sorry.
indictment? It's not a
The
count
overt.
against anybody. The count 55 is not a count against any of the 6 co-defendants on
Correct.
trial currently, yes.
correct. So it involves something completely and wholly unrelated from
Okay,
the drinks
right,
murder.
true.
Okay, I want to play for you. So I can show Your Honor the screen, but basically, if you click on that jail call, which I guess is Mr. Dorsey talking, it comes up on your screen. It says 0428-2022. I guess that's the date, 4/28/2022. And it says 2218. And then it says a phone number, 470-957-2893. And it says Dorsey and Boyer. Okay, it doesn't give a first name. It just says Dorsey and Boyer.
Okay,
There's no context for us to know who Boyer is. And this is the call that the state is saying puts us on notice that Mr. Boyer is somehow suspected and involved in the drinks murder.
Okay.
This is the call, and I just
All
want
right.
to play it.
okay.
Your Honor, Mr. Sharp, Your Honor, if I may just make one point of clarification. We did not represent and are not representing that. The content of that call puts them on notice. What we're saying is that the wiretap, the content of the calls in the wiretap are the basis for our search at getting the records. That's what
Okay,
put us on
and
notice.
the connection to the drinks murder, but it is this service of discovery that says, hey, that phone number from the wiretap is connected to the name Boyer. Is that what you're saying?
That's what we
Okay.
are saying.
It says
That's all I'm
Boyer,
saying.
and it just says Boyer, and
Okay.
if you play this, I would like to be able to play
Sure.
this.
This is a free call from
You already know who this is. Shout it out.
an incarcerated individual.
That's
at
Mr. Dorsey.
DeKalb County Jail. This call
All right.
is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Oh, that's it. Oh, the fuck going on? The fuck blaze? I'm in traffic, so you gotta hear that. All right, I get back at you. Too good.
That's it.
All right.
So someone says, I'm in traffic, I'll hit you back.
All right.
And
Okay, no, and Ms. Love's clarification is it's not that call that gives y'all that notification. It's the wiretap that gives you the notification because the wiretap has all these communications back and forth between this phone number, 404-957-2893, and Mr. Garlington's phone number. And then it's this bit of discovery that Ms. Love just told us about that says, and that phone number belongs to somebody last name Boyer. Okay, but they say they're not using it in the drinks murder evidence anyway. So that actually, I think, takes care of Mr. Williams' motion in limine filed very recently within the last hour or so, I think, saying keep that out. Is that right? And I have to confess, I have not asked you that particular motion, looked at it myself yet. I'm just basing it on Ms. Persfield's review of it. Is y'all are saying we want that kept out, and the state's already maintaining they will not introduce it. And so granted, but also unnecessarily so.
Thank you. Well, I added not only case in chief, but in rebuttal for that, Mr. Boyer. And then there's a second part to it. We received on Monday for the first time, Agent Bernie's expert report as to a April 26, 2015 shooting of Mr. Carter's tour bus.
Okay.
It's been referred before this honorable court as the Lil Wayne bus shooting.
Okay.
And the state has already put up, they said they didn't need to qualify Agent Racy. He's with ATF now. He's former detective in Cobb County, Racy, which is, I'm going to tell you, R-A-C-C-I, but I may have misspelled that. They've already put up painfully. It took days tracking phones. They have 3 to 4 different exhibits to your honorable court's right of your bench. They're against the wall, or they should be. I believe that's what they are. Anyway, the point I'm trying to make is now, for the first time, we're getting another expert.
Okay.
Never gave us this information before. And yes, I've had the records. I'm not complaining about that. But, you know, we look at everything and we test everything with our own
Right.
independent experts. So
Okay.
I want that excluded too. That was in the motion as well.
All right. So with regard to, that's two entirely separate, the issue I realize is way late discovery is what is being alleged. But we're talking about two different sort of pieces of evidence. So with regard to this Boyer plotting of the wherever the cell phone location is, the state has represented that they do not intend to use this. I'm granting the motion in limine with regard to particularly is at least this case in chief. But with regard to if it potentially needs to be used in rebuttal, at this point, y'all are on notice. Yes, it should have been produced before now, but we're also, I would say, pretty far away from hearing any evidence about the Drinks murder anyway. I am not going to make a blanket ruling at this point that it can't come in rebuttal either, because y'all got time. I don't know if it might need to be used or not. I don't know, but I'm going to leave that for another day if and when it does come up. Now, with regard to this second sort of chunk of information just been produced, Agent Bernie's analysis of what does that have to do with cell phones too, or just the incident?
He's a cell phone expert, so that's what it deals with. and
Okay,
It's
as
April
as
20.
to the, okay, so what do you say as to that, Ms. Love? Because if y'all have already presented your evidence, or what's your plan with regard to Agent Bernie's report and analysis?
Your Honor, would the court permit me to address the first part regarding the Boyer records and get it tendered the evidence, and then address
Yes.
the second
Yes.
part of the motion? Okay, so the state is tendering for the court's consideration states 2A Boyer records, which is the affidavit for the search warrant, and states 2B Boyer records, which is a search warrant itself for
Okay.
the cell phone records. And the court is correct. We stated earlier and state again that we are not attempting to use them in our case in chief. As well, Your Honor, I am marking as State's Exhibit 2C Boyer records.
Mm-hmm.
It is a screenshot of a search of the wiretap data for the number of calls that involve 470-957-2893. And the number of calls within the wiretap that involve this number are 501. So
Okay.
I'm tendering this for
Okay.
the court's consideration.
All right, thank you. And one as well as 2A through C are admitted. Okay, turning now to the Bernie
set
matter.
of plots regarding the Little Wayne bus shooting, the data, the cell phone records,
Mhm.
and their cell site location information was turned over, I believe, in July of 2022, if I am not mistaken. I'm almost certain that we turned it over in the first set of discovery that we served.
Okay.
So the data that the plots are derived from have been in defendant's possession since July of 2022. The plots that were made at the request of our office were requested after testimony and cross-examination, testimony elicited from through direct and cross-examination of our witnesses in the Little Wayne bus shooting.
Okay.
As a result of some of the questions and answers and the direction that we saw that questioning going, we asked for the plotting
Okay.
of the.
And when did you ask for that?
I'll get an exact date.
Give me a ballpark.
Hold on.
Give me a ballpark. Well, when did these?
In the last 6 months, that's the,
All
I'll
right.
give you a narrower ballpark because things were delegated and we did.
Okay. When did these people testify to the Lil Wayne shooting? When was that testimony roughly? January, June, April? Okay. So at some point After April.
That's a good, yes.
Okay, let me ask you this. At the point in time when you think it might be relevant to have a plot of whatever cell phones might have been involved, we've already heard everybody's testimony. Man, we'd like to shore that up with some expert rolling back in here and taking the stand again. We're going to get him to plot this. Would it have been possible at that point in time to share with the defense, hey, y'all, we're going to have our expert that y'all already know about anyway. Go ahead and plot this too.
Yes, that would be, yes.
Okay. Why was that not done?
So Bernie did not testify about these. He has.
I know.
Okay. Your Honor, if I may, I'd like to give the court first the more precise time that we got those records.
Not when you asked for them, not when you got them, when you asked for them.
That, yes. Before I go to that second question with the court's permission.
Okay. Go ahead. How long is it going to take to get that information? Can Mr. Christian work on getting that information?
It's already being worked on.
Okay. I mean, will the answer differ based on when you asked for the information as to why at the time you asked for the information, no matter when that was, you did not, even though you could have, say to the defense attorneys, I'm going to be getting this. I don't know if I'm going to use it or not, but I'm going to be getting it.
That is the best practice. And we did not, but I don't have
a good answer. I mean, and the answer could be because, man, there are only 24 hours in the day and this is chaos and, you know, we're doing the best we can. That could be your answer. I don't know. It's still not a good answer,
yeah, we know.
but let's just maybe nip this in the bud. Because I did ask you also to, at the lunch break, huddle with your team and see if there might potentially be anything else outstanding, whether Brady or not, because none of this sounds like Brady. It's just information that might come in trial that it would be, you know, just kind of like the way we're supposed to try cases is to sort of share each other's evidence to, you know, with the other side so they know what to expect. So were you able to sort out yet? Is there anything else out there in the universe that you think you're going to use?
Judge, I used the lunch break to get that information I gave to you earlier. We were feverishly getting that.
All right. So all right.
Right now, what I have for the court is that Reese testified on between May 13th and May 16th. So I need to clarify that. Okay. And the defense challenging him and as I said earlier, the questions and answers and the follow-up cross-examination elicited during that time period, May 13th and May 16th, is what caused us to request them.
Okay, that's fine. Okay, and essentially you acknowledge, yes, we could have gone ahead and let the defense know we were going to try to get this plotted. You just didn't. And I guess what I need to have happen going forward is that as this trial is going on, first, if there's anything outstanding like that, whether you've got results back or not, or if you're just like, after somebody testifies, you know what, this would be a good thing. Okay. Share it in a timely manner, which is like, not necessarily at the time it occurs to you, but at the time you decide to do it. Don't wait for the results to get back. Don't wait till you're going to call the person to the stand. At the time you say, we're going to do this, you give that information to the defense, okay? And then when you do get the results back, you can say, we're not going to use it after all. Or we are going to use it, here's the result. And that is going to go be the rule, be the requirement moving forward for everything. So if there's anything out there right now that's kind of in progress, tell them about it. And moving forward, as things come up, when you decide I'm going to be doing something about this, tell them about it. Okay.
Yes, sure.
So what amount of time do you need to get with your team and figure out, is there anything in process?
Friday at 5 too late, or you want me to?
I have Friday at lunch.
Okay.
Well, okay. I don't know what our
Yes.
Friday is going to look like, but yes, you can share it with them without it being in court. So yes, Friday by lunchtime. And you can just copy Miss Persefield on whatever it is you tell them.
Okay.
All right. And I expect that to be the rule that gets followed moving forward. Okay.
Okay.
All right. Any questions about it?
No, no.
Okay. All right. Anything from the defense on that topic and that rule? And I know it is not ideal, but this, you know, it seems that up until recently, this trial was sort of, everything was on a rolling basis. And I can't do a whole lot about that, but moving forward, that's what it's going to be. Yes, ma'am.
So, Your Honor, that's everything was everything was not on a rolling basis.
Well,
And the rule that you just implemented was already the rule.
okay.
Chief Judge Glanville, at a certain point, because we were receiving late discovery disclosures
All right.
all the time.
Okay.
And at a certain point, he said he was fed up. He spoke to the state. He said he was drawing the line there.
Okay.
And that any late disclosures after that, and he did exactly what you did today. Maybe not in those exact words, but
All
he
right.
said, is there anything else?
Okay.
So he gave the state this opportunity already, and he told Ms. Love specifically that if any other late disclosure of discovery came after that date, that it would be met with remedies and sanctions. So we're
Okay.
here again, and I'm just asking that before you exercise patience.
Don't exercise patience. Okay. That it was already supposed to have been in place and be aware of that. Okay. So, I mean, I think that's probably true. I wouldn't be the least bit surprised if Judge Glanville had already at some point said, all right, y'all, we got to
Judge
sort all
Glanville,
this out.
in fact, he has and did in fact say, hey, turn over everything you have.
Right.
And I'd only say that as trial goes and as we see the direction that
Okay. I mean, I
manifests
understand.
itself.
Yeah. I mean, trials are kind of living things. I get that. But if even if it took you 2 weeks to decide, so like by, Memorial Day weekend on May, whatever it was at the end of May, you were like, yeah, let's get this. It's now August. So you had all of June and all of July. So, I mean, the motion on the floor is to request that the plot by Bernie be excluded from this trial.
Your Honor, we would ask that the court, since that is the motion on the floor, deny the motion because the data that has been plotted has been in the possession of everyone. That's including cell site location data since July of 2022. Counsel for the defendant is correct that Judge Glanville said, turn over everything that you have. And you have a continuing discovery obligation.
Right.
So moving to exclude a summary of what has already been given, we would argue is an extreme remedy given that the information that is contained in that plot that was given to them has been in their possession since July of 2022. And this is something that we requested. I haven't yet even told, I don't even have the exact date that we received it back, but we did request it around May 23rd or shortly after that.
All right. And the plotting that Mr. Burney did, is that with regard in the report that's come back? Is that in regard to the Donovan Thomas murder?
No, the plotting that they're referring to has to do
Uh-huh.
with the Little Wayne bus shooting
Oh, right. Y'all told me that. I'm sorry.
that we put up the evidence of.
All right. So have you had Burney testify yet?
No.
So when I see on your witness list that you've most recently provided to everybody, that Burney is listed as your expert or not. I don't know if he's, expert with an expert report and phone records for count 2,
That's
which
in the
is
next 30.
dominant. Okay. So
we
is he then listed again for where?
Yes, he's not in the, he's also in the last 30 set of witnesses for a different act.
And is that the bus shooting?
The Chamel drinks. No, the bus shooting, we've already put up
Okay,
evidence of.
so are you planning to call him to say, and here's the plot of everybody for the bus shooting?
No, what we did was we introduced Detective Reese to do that, but the defense challenged Detective Reese's ability to do that.
Okay.
And so for that reason, we had Agent Burney to plot them.
Okay. Okay. So Gracie you had attempted the plotting through that witness?
Yes, we had introduced,
Okay.
we introduced and attempted to introduce plots of various numbers.
Uh-huh.
There were challenges to Reese's ability to plot various
Okay.
numbers.
Okay.
There were
All right. But you at no point after you knew you couldn't get it in through Gracie said, all right, we may be trying to get this in through Burney.
did not. No, we
Okay.
never did
right.
that. And I want to be clear that it had to do with the line of questions that were put upon Agent Reese.
Okay. So, I mean, sure. It only came up that this was a possibility after Gracie testified.
We only decided to do that after that. We were
Right.
intended to be done with that.
But it's still been 2 months since that time.
Yes. I can
And
see
so
that.
why is an appropriate sanction not at this point saying you cannot use that information through, period. You can't use that information. I can't let Burney testify to that.
Because 2 reasons. The remedy of exclusion, as the court is aware, is one that is extreme, and generally it would be appropriate when there has been some kind of harm and there has been some kind of bad faith. I'm not saying that that's the only time the court makes the decisions. Our argument would be that it should only be employed if there's something the prejudice.
Yeah, I
to the
understand.
defendant.
So how is it not bad faith? And I don't mean this personally, but how is it not bad faith when you've been ordered by a court, probably orally and in writing, that you need to produce things as they come into being and as you know about them, and then you don't do that?
Bad faith would be holding it back for some kind of advantage, tactical advantage. And if we're saying we don't have to put that up until the last 5 witnesses, and we are at witness 80 in a list of 175, giving them the records or the plots now, literally when we have people,
Okay, so that sounds more like an argument that they aren't really prejudiced because they still have plenty of time to handle it, right?
It's actually for both, because what I was saying is to say it's bad faith would mean that we held it back for, I mean, that's still not the only definition of bad faith, but we did not hold it back for any We did not intentionally keep it from them.
Okay.
It's,
So how is it that it came out on Monday or occurred to y'all over the weekend and you produced it on Monday? Is it because I mean, because y'all finally got together and said, all right, y'all, what else is there that we ought to be giving them? Why 2 months later?
so the moment that precipitated this disclosure,
Uh-huh.
I have to rewind and go back over everything that has happened. And I can only say that it may have been that the court, I know, it may have been that as we were looking at 30 witnesses out
Yeah.
and looking at Bernie,
Okay.
we realized, oh, Bernie.
Okay. So it basically was just the court saying, it's time to get organized and it's time to share the details about what your intended trial evidence is going to be that finally made y'all get organized enough to realize, oh, shoot, there are some things we have not shared yet. Fair?
It is the
Okay.
court's order that got us to do that.
Okay. All right. So that is probably not bad faith. That is it being swamped because there's a lot of evidence. But I am exercising patience despite the suggestion that I not do that. And I hear that you probably think enough patience has already been exercised. There is a long time before this witness is going to be called for this purpose. It is more difficult to prep for evidence as the trial is ongoing than it would have been before. It's more difficult to do it with 2 fewer months' time than it would have been with 2 extra months' time. This needs to be the last of it. I mean, it's sort of like when somebody comes before me on a probation violation and it's the first time I'm seeing them. I don't know what they thought about getting away with anything before that. But once I talk to them, I expect them to abide by it. I expect you to abide by it. So between now and noon on Friday, you better make sure you have got all your ducks in a row and you have shared those ducks and ducklings with the defense.
Yes.
Okay. I'm about ready to move on from this, but yes, ma'am.
Okay, Your Honor, I'll be brief.
Speak into your mic.
I'll try to be brief.
All right.
Your Honor, in all candor to the court, I believe that the state is arguing as if it's a first argument to you because they know you haven't been here for 19 months. These arguments, I've heard them so many times, it's countless.
I understand.
Right. And for the state to argue it's not bad faith, I'll give you an example of things that we've been through before we had the opportunity for you to be presiding.
Can I ask you a question before you do that?
Sure.
Is this something that is not already included in one of the numerous motions for mistrial or to disqualify these prosecutors?
I don't think so, actually.
You don't know?
I said I don't think so,
Okay.
but I'm not sure.
Go ahead,
But this
share
is
it.
specific about discovery, disclosure,
All right.
and timely disclosure. The state's been caught before. Specifically, I remember a late discovery disclosure that once it was disclosed, it actually had a comment on there that was supposed to be internal that said, do not serve yet. They did it on purpose. And how many times can you say, oops? How many times can you repeatedly, systematically make the same mistake as an experienced litigator and say, it's not bad faith?
Okay.
Your Honor, I'm just asking that the rules be enforced, because if they're not really rules. They're just aspirational.
All right, I understand. And we are instructed ad nauseum by our appellate courts. They probably won't like my use of that term, that exclusion of evidence is an extreme sanction, and that prior to a trial court instituting that as a sanction, the solutions that need to be thought about include a continuance, which is not going to happen here because we've been on a continuance for a while here anyway. A continuance here, it's, no, they cannot bring it up next week. It needs to be way far down the road, which they are representing that it's going to be anyway. So it'll give y'all time to look into whatever it is. And I understand what you're saying and I hear you. And the answer to how many times can it happen? Maybe 0 more times. Okay.
Not trying to keep us from moving on, but related to this,
Yes.
my understanding, I'm sitting way back here. My understanding is the state admitted some court exhibits to include the affidavit and the search warrant
Right.
for Mr. Boyer's
Yeah.
phone records. Is that correct?
Yes.
Could the state, we still don't have those.
Okay.
So could the state send,
Is by email or should I have copies made of these?
and additionally, my colleagues are correct. We would also like all reports, the statement that the state has made is there's been a continued investigation into this case, into Mr. Boyer, and we would like all associated reports, investigative reports, summaries, supplements involving the continued investigation since our client's arrest.
Reasonable. Miss Love, you understand?
Yes, yes.
Everything with regard to the police investigation of Mr. Boyer in any kind of involvement of his in any of the crimes indicted in this case. And let's ask for it before the end of the day and make sure you have it before, it should be by like sometime mid next week. And if it is going to be any longer than that, you let us all know why. Okay, and so sharing the affidavit and search warrant and whatever else it was, is that something y'all can do electronically or do I need to get copies made?
I'm actually checking to see if we brought over physical copies
Okay,
of both the warrant and the affidavit. Yeah.
all right, let Mr. Adkins look for that, okay? Huh?
Yes, it is. We can provide physical copies. Of the
Perfect.
affidavit. We do not have a copy of the screenshot of the number of times the number shows up in the,
Okay. All right, but you put that on the record and y'all, 2C, and y'all are welcome to walk up at the next break and look at it, but it essentially is just this one line that shows however many 500 and something times, okay? And she's gonna share hard copies of 2A and B. Okay,
Just
yes.
during the trial, you're going to be met by Mr. Williams with an objection to Agent
I'm sorry,
Bernie's.
say that again.
I'm going to raise an objection to Agent Bernie
Okay,
about the going backwards, what's testified to. And I heard
okay,
what the prosecutor said about, oh, this came up because of cross-examination. My memory is strong. My memory is that all of our objections to Agent Reese testifying about cell site location data was overruled. The state put in all this evidence for a long time about where
Okay.
every phone was. So you'll be getting a cumulative.
okay. If that is in fact the case, yes, please point me to where that is. And if it all came through Agent Gracie anyway, then I may revisit my ruling. But let's not take that up now. Y'all can file something and point to that part of the testimony. Okay. All right. All right, so back to the plotting detail that we are engaged in with regard to Mr. Zachary's April 2017 statement. And let me, before we get back down into that, I was going to go back and listen to a portion of the video that had to do with item number 13. Let me find my list. Gotta find my list. But y'all have your list, so. No, that's fine. I'll just need to have somebody from my staff walk into my chambers and find the 3-page list with my scribbly handwriting all over it and bring it up here. But I've got an electronic copy of it anyway. I don't know where it is. Anyway, it had to do with, oh, here it is. Here it is. I found it. Page 54, lines 18 through 22. I was going to go back and look because I was trying to figure out who they was. So having listened back a ways and listened forward a ways, it's pretty clear to me that Mr. Zachary at this point, when they say, when the investigator asks who they say killed him, and he responds, shoot, they say Woody and them. I don't know that for a fact. That the they there is who do the people that you were with at the condo say. So I am going to actually go ahead, and I think I had tentatively ruled that out before, but I'm going to permit that after all. Because that's, to me, pretty clear that he's saying that very evening, this is what the group was saying. All right. Okay. All right, so I think we are were we on item number 53 at this point? Anybody?
We had gone up at least to 150, page 157, the last address on.
Okay, right. Great. So then item 53 is on 158. Okay. So 158 lines 12 through 21. Okay. Okay. So then we're at 159, 6 through all of 160. And I guess the objection is this is incidents entirely unrelated to anything that is a part of this indictment and that it's hearsay. Okay. And what's the state's response?
I changed my prior representation. I don't have an objection to that.
Okay. So that is out by agreement.
So,
all right.
So just, I'm sorry.
Go ahead.
Starting at line 6 on page 159.
Right,
Yes.
yeah. Okay, so the next is 170, lines 10 through 17. Oh, well.
I've made my objection about what Meghann said being not in furtherance of the conspiracy, but I would concede, I'm not withdrawing my objection, but I would concede that this would fall under that same
All right,
reasoning that you've already admitted the other ones.
okay, thank you. Essentially, we don't need to re-argue it. Got you, thank you. All right, so my ruling as to this will be the same for the same reasons. And are the items listed in 56 essentially the same again? Same
I
argument?
believe so. I'm just reviewing it to make
Okay.
sure there's nothing
All right.
additional. It's all over the place. One example.
All right, looks like the first chunk, 174 through 177, is all this kind of same thing we've considered argument about. Do you agree with that?
I do.
All
I
right,
also agree that the second chunk
okay,
as well.
all right,
I'm looking at the third right now.
all right. Same for that last one too. Do you agree that the last one's the same as well?
I'm almost done, Your Honor.
Okay, I'm sorry, I don't mean to be rushing you. I just don't want to be
I appreciate it.
thinking that you're done and you're waiting on me or anything.
I would agree that it appears that that is all based on what Mr. Garlington said to Mr. Zachary.
All right. Okay, and so for the reasons stated before, I am going to admit those three portions of the transcript over objection, is obviously assuming they end up needing to come in and foundation is otherwise
I
laid.
do have a motion, and I believe that, or not a motion, but an issue that is in this section, and it's going to, it's interspersed throughout both.
Okay.
And when Mr. and when Mr. Zachary
Okay,
testifies, presumably.
can you talk into your mic?
Yes. So my concern, I understand that I disagree with it, but I understand that Mr. Zachary has claimed that my client made certain confessions to him. I would argue that we need to figure out on my client's behalf what we're doing with the confessions that were made allegedly by Mr. Kendricks to Mr. Zachary, because that is, as I understand the law, I don't see that seems like it's spilling the beans. It does not seem like it, and I understand that statements made by Mr. Kendricks, if the jury believes that he made them, can be used against Mr. Kendricks. They should not be considered against my client, Mr. Stillwell. And I would assume that all the other attorneys who are representing neither Mr. Stillwell nor Mr. Kendricks would have an argument that those statements should not be considered against their clients if they're being admitted as statements by a party opponent.
And for what it's worth, Judge, if I can just join on behalf of Mr. Williams, I was getting ready to kind of jump in and say the same thing, that I understand the court's pronouncement previously. I understand the state's position as to what they contend those statements are. But in so much as we're charged in this indictment, and we believe that those statements may be admissible against those particular individuals who made them, we do not believe that they're admissible against us. We believe that they do fall under the category of spilling the beans, and that they should not be, they may be admissible against that person, but not against us. And we'd object to those statements being admitted.
All right.
Your Honor, if it were that it was, we were only saying statements of a party opponent, in that world, I would have one argument. In this case, we have that they are co-conspirator statements, and all of the defendants currently on trial and the people who are making the statements are, and the persons to whom they are making the statements are alleged co-conspirators,
Right.
which makes them admissible for each of the defendants.
It makes them admissible as long as it is still a statement made in furtherance of the conspiracy.
Right.
And so y'all are going to need to talk detail to me about when in time and to whom and under what circumstances co-conspirator statements were made, because I can't make a blanket ruling that everybody on trial or everybody indicted, everything they ever said to each other falls under that exception. So let's maybe sit that to the side, but come back to it to the extent I haven't already made a ruling, because it just is going to depend. Okay. So, I mean, I don't know, let's just, let me add that to my list of things we still need to do, but y'all are going to have to bring to me the detail about what and when and to whom and all of that.
So, Your Honor, that is for sure. That is what we expected. What we were undertaking here is not even an assertion that, okay.
Yeah, so we'll do that another time. One other thing I noticed in what we just were looking at is there was mention made of a McDonald's video. And I think just maybe in passing, Mr. Sharp, you mentioned that nobody's ever produced that video. And I just want to make sure, does the state have possession of any video from McDonald's? And if not, did y'all or somebody from law enforcement go see if any such thing exists?
Your Honor, yes, evidence through testimony has already come in that at least one investigator, along with her partner, attempted to obtain McDonald's video. She was not able to. The lead detective was not able to, did not. We don't have any McDonald's video, and we don't have evidence that anyone has McDonald's video. Okay. And as the court already knows, in the portions that are reflected in the transcript, it says someone was trying to
Right.
get McDonald's.
Okay,
Yeah.
just want to make sure. Okay. Then item 57 on page 185. You're going to withdraw it? Okay. All right. Item 58. Well, I'm sure these, it started out as kind of notes to yourself.
Yeah, yes,
So
I
don't
did
worry
not
about
do
it,
the
but-
best job of laying out exactly what my objection is, but it starts out with speculation, it seems to me, about on behalf of Mr. Zachary about why people are not hanging out with Woody, who's Mr. Copeland, anymore. And then they get into a discussion about a word that I don't even use, quote unquote, snitching. And I just don't know what relevance any of this
All right.
discussion has to this case.
So to respond to Mr. Sharp's relevance objection, what the court has, just to give some background, in 186, on page 186, starting at line 1, Dennis flat out asks, after Woody came down here and talked to the police, it was almost like everybody was distant from him. And Mr. Zachary says, yeah, we have, and I anticipate we will here, we'll see through Mr. Copeland. But there are multiple statements that Mr. Copeland gives regarding his distancing from other members of YSL after he went down and talked to the police. That's one thing. Later on, as in line 8, so in line 6, Detective Dennis says that did they distance himself from them because they thought he was snitching?
Mhm.
And Mr. Zachary clarifies, it's not about that, but he snitched on the person who shot at him.
I mean, it essentially ends up being a conversation like, no, it's that he got the police involved at all. These kind of things ought to be handled amongst the people that have issues with each other.
Yes, and
Okay.
so for 2 reasons, it sort of tells how they operate, and also to the extent if Mr. Copeland says, no, I didn't say that.
Yeah.
It would serve to impeach that and to further show that this is how we operate.
Okay. I mean, I think it's certainly relevant to showing how they operate. Now, if there is something more in particular about, a certain phrase or a certain question that you think could be excised, let me know that. But I think the overall concept is a relevant one in this trial.
Judge, let me interpose this if I can.
Okay.
I hear what the court's saying. I hear what prosecutor's saying as well. But for it to be a relevant issue in this trial, it's got to be relevant to, for example, someone's testimony. And the discourse that we're looking at here isn't them saying that, for example, Mr. Copeland isn't saying something or is saying something, or people are getting upset at him for snitching. They're having this and I'm going to use Mr. Shaw's word, kind of this philosophical discussion about, whether people should be talking to the police or not.
Right.
And you can have that discussion. They can have that discussion without it and have that opinion, because quite frankly, the detectives are also interjecting their thoughts on why people do what they do. That doesn't make it relevant. They're having this discussion about whether it's appropriate to talk to the police or not. But there's nothing about that discussion in and of itself that really tells us anything germane about the facts of this case. You can say that, for example, the state can say, for example, well, this goes to show how they operate. Well, a person can have an opinion without it going to show that they operated in this particular manner in regards to this case.
All right. I agree, and you can make that argument to the jury. Thank you.
I think it also goes to, it borders on propensity as well. To say that someone has a propensity to act in a certain way that might be consistent with whatever their theory is for this case. So I just think.
Okay, well, it's not specific other acts. And if it were, it's intrinsic to this set of charges anyway. So overruled. Thank you. All right, moving to 191, item number 59.
I withdraw that.
All right. Then 192 is our next one. All right, and that's lines 16 through 21, Ms. Love.
We up to 20. Yes, we don't have any objection
All
to
right,
that.
16 through 21 of 192 out by agreement.
I withdraw 193.
Okay. All right, so you'll withdraw as to your item number 61?
Yes.
Okay.
I'll withdraw 62 as well.
Okay.
And Your Honor, for 63, if I don't want to withdraw it, because if you saw the way, if you agreed with my arguments about Deamonte's statements, I think it would be inappropriate for Investigator Dennis to repeat Deamonte's statements, but I would, for the purposes of this exercise, I would concede he is repeating alleged facts that Mr. Zachary is saying Deamonte told him that fall under your previous ruling.
Okay. All right. All right, so that's based on the same rulings as before. Okay, now we're at item 64, which is on page 206.
And Your Honor, I know you have no context for this at all. So in discovery, there is I would term it as completely innocuous social media post of my client that may have been posted on January 10th. I believe it was taken at New Year's.
Okay.
January in 2014 turned to 2015 with my client just kind of standing there, and it said something to the effect of looking at the city with a lot on my mind,
Right.
or something like that.
Okay.
Somehow that's being posited as some sort of confession, or
Right.
which I don't really understand. It has not been admitted into evidence yet. I'm going to argue that it should not be admitted into evidence because it has no relevance. So there's reference to this
Right.
picture, and
Okay.
I guess pending.
Sorry, go ahead.
No, you're tracking.
I understand. So do we even have any idea what time it got posted in relation to Mr. Thomas's murder?
Your Honor, the time, I believe, is on the post, so it's after, make sure, the time is on the post. And I
Okay.
the time. And my memory that I'm going to confirm is that it's around 10 something in the evening, but I'm going to confirm that. I may have
What time was the
7, it's a little after 7.
7 something PM?
Yes, it was a little.
Okay.
7:22 to 9:01 call
All right.
at night.
And so it was posted by Mr. Stillwell on January 10th at 9:58 PM is the time and date of the post, on the post. So,
January 10th at 9:58 PM.
yes, after the, yes.
Yeah, that's going to be permitted.
In that case, Your Honor, there's nothing there's nothing about this discussion of it
Right.
that is by itself objectionable. It's just, I object to the evidence itself. So that's why I
Okay,
was-
yeah. And I mean, I don't know why on earth this part of this would end up being something that gets submitted as a prior inconsistent statement. Who knows? But to the extent it does, it can come in because I think that the evidence itself would be admissible considering it's the post and the commentary is 2 hours after the murder. Okay. All right, takes us to 2:15.
This is more y'all's. You like it? Go ahead, Keith, you answer it however you want. Withdraw? We'll withdraw that objection.
All right. All right, now we're on to page 222.
I am, on this one, it's a very simple objection. They're talking about the phone records and alleged communications between Mr. Winfrey and Mr. Williams
Uh-huh.
on the night of the shooting of the Lil Wayne tour bus.
Okay.
Mr. Steele and Mr. Adams Investigator Underwood interjects and says, Mr. Zachary is saying that Mr. Williams didn't answer the phone. There was no communications.
Right.
Investigator Underwood interjects and says, that ain't what them phone records say.
And that's not true. Right?
That's correct.
Okay. Any issue with taking that out, Miss Love? Just lines 24 and 25 of page 222.
I don't mind.
All right. Thank you.
Good job, Max.
Okay.
You guys, look at 2.3 minus 1, 2, 3. Or really 1 through 12.
You're going to make an argument that this should not be redacted?
So yeah, I don't have, I'm sorry.
All right.
I don't object.
Okay, so item 67 as listed is out by agreement.
And the next one,
Yeah,
I don't have any objection.
all right. Thank you.
And so part of the reason that my initial response or reaction to it was to keep it in is only that he was, Mr. Zachary, throughout this conversation, this portion of it, he's talking about his own observations as he was with them.
Right. Not this particular part. So that's essentially, I mean, I don't know if the overlapping conversation actually, y'all can understand it adds anything, but at least what's on the transcript 20 through 25 is not additive to anything. So can we just strike the entirety of this page by agreement?
Yes.
Okay.
Yes, Sean.
All right. All right, the next one, 225, 1 through 6, appears to be admitted speculation. Unless I'm missing something.
One through I agree and I don't object, and I was actually looking further down.
Okay.
I had no objection to 1 through 6.
Okay. Okay. Now turn into 228.
All right.
All right, Ms. Love.
So Judge, this portion of it, the reason I wanted this in is that
So I know why you wanted it. Why is it admissible?
That's the question.
so, all right, so I don't have any objection to 11 through 17. But Mr. Zachary's assertion that they, and the way I read it and understood and listening to it, YSL knew that Donovan Thomas's gang had shot up Thug's car. I believe that that statement reflects a general understanding that he shares and that his cohorts share within YSL. And I would argue that that part goes to prove count 1, and it provides not that we need a motive for murder, but
the Woody get on Instagram flashing money and junk, and the Nut Gang had done shot up Woody, I mean Thug's car.
no, but he says you listen to some nuts gang, if gang, shot up, and
But I mean, is that the part that you want? Is that like basically lines 17 through 19?
Yes.
But Judge, you don't look at it in a vacuum, right? If we're talking about looking at it from line 11.
Yeah, no, I'm just trying to get a handle on what everybody's even arguing. So if she's saying, trying to figure out now, like she's saying, I don't have an issue with some of it. I'm not making a ruling right now. I'm just trying to get a handle on things.
Yeah, I'm just trying to point out that the analysis is the same, whether we're going from 11 to 17 or 11 to 19, it's still the same analysis. That what the speaker, what Mrs. Zachary is doing is he is giving his assumption as to why something is happening, what people are thinking, and it's clear, right? Where he's talking about, well, that's what everybody thinks, and it's because Woody got on Instagram flashing money, and people think that the Nut Gang had done shot up Woody or Thug's car. All of that is assumption and speculation on his part, and it's just not. It should not be admissible.
Okay, I don't think it's an assumption on his part that Woody got on Instagram flashing money, is it?
No, not that part.
That's a fact.
That's a fact.
Okay.
Woody got on Instagram.
And it's also, I think, a fact, but I don't know, y'all can tell me differently, that people from IF shot up cars in the parking lot that night.
They believe that it's getting shot up.
Right. So someone's belief, though, is not evidence, and there's certainly been no evidence. That's an issue for a jury to make a determination about.
No, the fact that this group of people thought that this other group of people that they are beefing with have done some shootings against people in their group is relevant, whether it is true or not. Their thought about it is relevant to the issues on trial right now. So to me, the only way this 17 through 19 comes in is if Mr. Zachary gets on the stand and says, no, I had no idea that Woody got on Instagram flashing money, and or no, nobody that I ever hung with ever thought that IF did anything about the shooting in the parking lot that broke a windshield on Thug's car.
Right, it would have to be an inconsistent statement. He would have to.
All right, so 17 through 19, that little portion, if he gets on the stand and says one of those things, then whichever part of that is inconsistent, you can say, didn't you on whatever day basically say this? But that doesn't mean 11 through whatever the next page is. That means that Woody got on Instagram flashing money, or Nut Gang done shot up Thug's car, okay?
Yes.
The rest of it does seem like, well, if other people think such and such, here might be the reason they think it.
They don't, I don't see that they have an objection beyond 19.
It's page. I believe it's supposed to say 2. Well,
I thought it went all the way to 229, line 19.
yes, that is correct.
The one that I have.
No, I know, it just says 2219, but he means 22919.
So I have a different response to that understanding as to 228, 20 through 24, and
Okay.
further there.
All right, so 228, 11 through 15, or the beginning of 16, is out by agreement. 17 through 19, only in under the very limited circumstances I just relayed. So now 20 through 23.
So throughout this trial, again, there have been battling contentions regarding the relationship between Deamonte Lamar, who is Rich Homie Quan, and defendant Williams. So when ADA Sprinkle asked whether Rich Homie Quan, and actually this part has there's been evidence that, Rich Homie One was affiliated with
Okay,
Donovan, Gang.
okay.
So when he asked Quindarius Zachary that, and Mr. Zachary says yes,
Yeah,
and began talking about it,
uh-huh.
this part of this states it challenges the notion as he goes further on and explains. And I want to get to the part where he does.
Oh, well, let's just deal with this part right now, 20 through 24.
So when he says, when Mr. Zachary says yes,
Yeah.
And then talks about the fact that Thug and Nut were hanging together.
Right.
While Woody and Shell Kell were shooting. each other.
Right.
It's just his observation. I mean,
Okay. Yeah.
I don't
That
have a
part,
problem with
you don't have a problem with that part. All right, so that part is in, there's no objection to that part. Okay, so now we turn to 229, 1 through 19. And what's your objection, Mr. Chart, to 1 through 19?
Mr. Zachary seems to be talking about not just generalize how this isn't a situation where previously it was argued kind of how the group felt, but he's talking about very specific instances, it seems, where they were asking about Jeffery calling, Mr. Williams calling, speaking with Mr. Thomas, and then he's saying, no, Woody called Shell Kell, though. And those are very specific instances.
Right.
And I don't know that I don't know what his source of knowledge of that is.
Okay. All right, so hang on. 1 through the beginning of 5. Ms. Love?
So there have been assertions regarding this call and there have been assertions.
Okay, so is any of the assertions that there's evidence to back up the assertion suggested in Investigator Underwood's question on about what Thug did? I know that there were suggestions that Nut might have tried to quash something. Is it just pure speculation that if he did in fact do that, that Thug said F you?
I don't object to that kind of.
Okay. All right, so 1 through at least 4, the answer no is out by agreement. All right, what about the rest of it? Beginning, Woody called Shell Kell, Nut's hanging with Thug. And Nut really doesn't get involved with this.
Your Honor, my major opposition to this is well, I'm going to defer to Mr. Adams on this if he has a problem with it. I don't really have that much of a problem with it.
All right.
Neither do I.
Okay. Then the objection to 129 line 4, beginning with Woody call down through 19 is withdrawn. Thank you. All right.
And, Your Honor,
Yes.
I would endeavor to establish a foundation before I made any kind of proper or ask flat out that kind of question.
Okay. I mean,
As is the rest of it.
sounds good. Okay, moving to item 71, page 235.
I know you are.
Okay,
This is where I think I have a problem. And I know that in some ways this answer is helpful to Mr. Williams. I don't, Mr. Zachary, he's saying he doesn't know.
yeah,
And who killed Donovan Thomas when it comes back to it. He's saying what he heard from Deamonte on Garlington, but then in a conversational, the way we all have conversations, he puts out a hypothetical. If you're talking about Jeffery Williams, if your circle kills somebody, they're going to think you or that all of them together. So,
yeah.
and the hypothetical, if your circle kills somebody, I don't think it's appropriate to have that hypothetical thrown in there because it assumes my client's guilt.
Ms. Love?
Your Honor, this is two things. We're talking about a circle, we'd argue he's describing a group. He's acknowledging the existence of an association. And he's saying these words to the police after he is, according to him, told that two of his group have caught someone down bad. And he's essentially saying, if your clique, if my gang, calling it a circle, but they also at various points throughout and the earlier interview, they referred to it as a gang in 2015. If my gang kills somebody, they're going to think that all of them be together. So he's acknowledging the association, and in it, he's speaking on something that defendants Kendrick and Stillwell, according to him, have relayed to him. And that's the way that he tells the police that Mr. Kendrick and Mr. Stillwell told him, we caught that in down bad. And he talks about what we caught him down bad means in the 2015. And even in this one, he talks about, I think Mr. Bailey asks, what does caught him down bad mean? He's asked during this interview, and he clarifies, we shot him.
Mm-hmm.
He says that. So I would argue that this is relevant, and it goes to prove count one at the very least. And
All right, so because that's just his circle, if Mr. Zachary gets on the stand and says, none of these people hung with each other, you can cross him on what you called these people his circle before.
Okay.
Okay, the rest of it out.
Okay. And Judge, my number 72 is cut off. So is it 239, 20, lines 23 through 24?
I think so.
Yes.
Okay. I didn't have any objection to that. That was the one that
Okay,
that's like 70.
all right. That is. $72 out by agreement. All right, moving to 245 through the top of 240, the very top of 247. Bless you. Yes. Miss Love.
So
Seems inappropriate to come in.
right now, yes, right. There's obviously going to be discussion about what he's given and all of that, but right now, I agree. I don't have any objection.
All right.
To that.
Thank you.
But up to, and I'm just not objecting to all of what's on actually lines 1 through 18, because when he's asked.
Wait a minute, 1 through 18 of which page?
245. Because that whole
Okay,
conversation up until that point is about who's going to jail, what time you should get,
okay,
and all of that. But at line 19, when he's asked, do you realize how much you contributed to what's going on?
okay. Mhm.
He's acknowledging some things.
Okay,
I mean, he's pled guilty to these charges.
But-
I mean, I don't really foresee him.
okay, well, this is only if he says, I had no involvement. Then if she presents the guilty plea and he says, I only pled guilty because I just wanted to get out of jail and I had already served enough time, then she can say, well, I mean, it's also because you actually did them, huh? So under that circumstance, 19 through, 245 line 19 through 246 line 1 would be okay.
And as to lines 2 through 14, depending on how he testifies. So, Mr. Zachary at first pushes back on the getting guns for
Uh-huh.
them, but he was also convicted of straw purchasing.
Yeah, and he's
And-
busy saying, yeah, I did it. I was young and stupid, but I did it. So, okay,
So actually it goes down to 18.
all right. So that's 3 through 18 potentially.
Yes.
Okay.
And I don't have any objection to 19 to 25.
Okay, so 19 through 25 out by agreement. So would that go all the way
It
to
does.
line, okay, so through 247, line 2, okay. Thank you.
And Your Honor, 74, the next one is, would fall under your previous rulings about Deamont's statements
Okay,
to Mr. Zachary.
okay. So on that same basis, that part would be in. So now we're looking at 249, line 22 through 252:15.
I don't have any objection to 22 to 25 on 249. And up through 15 on page 250. And actually, the rest of, because it's just a little clip that I want in, and it's just not gonna play well trying to get in that one. Deamonte, your boy, yeah, it's. not
Yeah,
gonna-
okay.
all that.
It goes all the way through, at least the objection goes all the way through 252, line 15. So let me know about 251 and 252.
Now, 251, again, only assuming that, you know, he makes some assertion that makes the fact that he's sitting right there with his attorney relevant, when he's doing a proffer.
Okay.
Um,
Okay, so
and
if he gets on the stand and says, man, everything in that statement, y'all coerced me into, then you can say, your attorney was right there.
there's no reason, I mean, I don't,
Okay,
absent a reason, I don't object, absent.
all right. So it, but otherwise, you are good with. Okay, so what about all of 251? And then on to 252, line 15. Which may,
All of it, rethinking how I was looking at it, I don't have.
okay, all right. So that is out by objection with the one caveat that if he says, you can't believe any of this because I was being coerced, then we can say, didn't you have an attorney with you? Okay.
And also, Judge, I'm not, there's a portion of 252 that wasn't objected to. I haven't voiced to the court the two areas that I would argue need not come in. Because I think that we should, for clarity, just go through what has been requested by the defense, but I'd like an opportunity to.
Okay, so we are now at the end of the defense's requested redactions, exclusions as to this statement. So if you think that there are things that the state believes should not come in, now would be your time to present those.
So, Actually, that part that I was going to say, that part is already, I don't have any objection to the 252 through line 15. That was actually.
Right. Got it.
And then so the part that the state had concerns about it were page 205. Page 205, where Dennis says, who do you believe has something to do with it? Just Rudy by himself? And Zachary says, yeah, think about it. And then Dennis says, but they had to know what is their motive, what would be driving them to participate in it, and Zachary says, Rudy. Essentially, now it's him saying, I think, despite what Mr. Kendrick and Mr. Stillwell have told me, I think this. I don't have I would argue that it is a false assertion, and understanding it is an inconsistent statement with what he has said earlier, one could argue that it's admissible, but just because he's saying, he's asserting that it's speculation.
I don't follow you. Are you saying that 205 lines, I guess, what, 4 through, I don't know, 1 through 23?
No, it was
7, I don't know, 11, okay. Well, 11 starts with by itself, so there has to be some reference to Woody before then.
9.
Okay. And maybe the indiscernible part on 8 is where he mentions Woody. You might want to go look back and look at that or listen to that, but okay, so he's saying, Zachary is saying, I think this was Woody.
Let me go.
And if the others were participating, then it's because, you know, he got good talk with them. So when would you be planning to use that?
I wasn't, I think I was, the court.
You want it,
Yeah.
you want it out.
Yes, that's what I was saying.
Okay, and why?
It wasn't addressed, and I was saying that it should come out.
Okay, why?
Because he is asserting that I'm just speculating. I don't believe he's.
Where is he asserting that I'm just speculating it?
When he says.
Oh, who do you believe? Okay, so this is like, here's what I think. So, I mean, yeah, it's relevant if he's saying these 2 people told me that they had involvement.
That's where I was.
Yeah, okay, so I'm thinking this is not redactable unless, yes, okay. Any other parts?
No, that was.
Okay. So we've gotten through the April 13th, 2017 transcript, that interview with Mr. Zachary. Let's take a bathroom break. Be back in about 12 minutes at 3:30.
Yes, sir.
Okay. All right, before we dive into what I think is going to be our task for the rest of this day, which is going through the other statement, the 20, I don't know what date, what is the date of this?
August 5th, 2015.
Okay, the August 5th, 2015 statement of Mr. Zachary and potential objections to that. Is there going to be a 4:30 to 4:45? Hey, Judge, guess what else happened? Revelation? Because if so, go ahead and tell me now.
I'm going to apologize.
That is not a disappointment. Okay, so where are we on, and I know we've got all day tomorrow. I don't know if I have told y'all or not, Friday morning, we will not be in session. I think I mentioned that I had a conflict and that I just didn't know with regard to Friday afternoon, and we probably will make that call a little later. I mean, hopefully we can have a really productive day tomorrow and we can have Friday off from active court, and then have the jury on Monday. But I still need from y'all, if you want some kind of a 105 limiting instruction, that contingent type instructions for our various scenarios we might face depending upon Mr. Copeland's Monday morning decision about whether to take the stand or not. And then if he is going to take the stand, I think y'all had said everybody's happy with, well, not happy with, but everybody is in agreement that what he then said on June 7th, 10th, and 12th prior to the motion to recuse is fine and is in. So with regard to after the motion to recuse, and it sounds like, honestly, there was kind of almost a clean break with regard to prior to the motion to recuse, he had not really gotten into any of the testimony concerning the Donovan Thomas murder or questioning about that. And of course, honestly, I bring notes up and then I don't know what happens to them. No idea. I know. And that, does everybody agree that basically, I mean, I think it was like on the, I don't know, because I wrote it down, now I can't find it, but that none of that was before the motion to recuse. Everybody agree with that?
I agree, Your Honor, there was definitely a clean break.
Yeah.
And the majority of the days after the motion to recuse consisted of
Playing his January 22nd and his February 10th statements, right?
yes.
Okay, so let me ask you this. You disagree? Okay. What's your recollection of it?
There were questioning and
Here it is.
the video audio of the early morning hours of January 11th, 2015 recording with Detective Thorpe, Thorpe, and Mr. Copeland was played in its entirety for the jury before the motion to recuse was filed. And then there was a second audio video, January 20th, 2015, that was also played. That day.
After. Did you say January?
Yes, it's hours after the Guffbit killing. The killing is
Yeah.
January 10th,
Right.
7:22 p.m.
Uh-huh.
in 2015. Early morning hours of January 11th, Mr. Copeland is with Detective Thorpe.
Right. And that got played after. And then what was the second one you said?
January 20th. I'm going by my memory.
January 20th, not February 20th.
Well,
Okay.
no. There's maybe it's January 21st. There's a 2 in January, 2 in February.
Right.
1 in.
Well, anyway, whatever those two statements were, somebody can go back in the record and look. But that was most of what occurred afterwards.
Before the filing of the motion to recuse.
Oh.
That's what I'm trying to
Okay.
articulate.
All right.
There was discussion of Donovan Thomas before the motion to recuse. That's why I wanted in. There's a lot of exculpatory information.
Okay. So y'all can agree to whatever you want to agree to in terms of things that are before the jury post recusal motion.
This is pre-recusal motion. That's why I wanted it.
Pre-recusal motion.
Yes.
Okay.
I think, Connor, there's no, we don't have differing opinions about pre-recusal motion as long as he continues to testify.
Right. Agreed.
So
Agreed. Yes. So whatever is, if he continues to testify, whatever has already been tackled pre-recusal is fine. And you are saying that part of that, there was at least one, maybe 2 videos played pre-recusal.
That's true.
Okay. And so those videos, y'all, was it like the entirety of it or? I mean, it seemed to be most of the day's transcript was video played. But, but then video was played on the 17th also, which was post-recusal, right?
Yes.
And that was maybe, I thought maybe that was January 11th and February 20th. Okay.
Those were played prior to recusal motion.
Yeah, no, I'm asking about afterwards. I mean, I'm asking about before and after, I guess. I thought on the 17th, which is obviously after, that the January 11th and February 20th video statements were played.
I believe that is correct, and I'm making sure. That was my memory. My memory was that the full video, she played portions of videos prior to that, 17th of the last.
Right, but some little snippets, right.
But the full videos were not played, and that was what we had discussed internally, and I thought that was what we came to, that the full videos were not played until after the motion for recusal.
Okay.
And the questions that led to them, so there were questions, and then there was the playing of the video, the ruling.
Okay.
True. January 11th was played and January 11th and February 20th
Yeah.
were played on 6/17. That is true.
Okay.
There were snippets before that and discussion before.
All right. So in general, in terms of an instruction to the jury, a couple of different things. All right. Yes, the January 11th and February 20th videos were played post recusal motion. The contents of the January 11th, February 20th videos were played post recusal motion. The contents of the January 11th and February 20th videos are not going to change. Are y'all proposing that we have the jury watch the entirety of those again? Simply because they watched them after the recusal motion? And I'm just asking that because I'm trying to figure out the logistics. And y'all can huddle on that if you want and give me an answer tomorrow. But in terms of thinking through how we instruct the jury and how we handle this, that is an issue to be considered and for y'all to come up with an answer about, okay? And then is there, other than those two videos, however y'all want to handle those, is there other testimony, questioning and answer, testimony that y'all want to come to some sort of a stipulation about? And yes or no, either of those is fine. Just, I need to know how to deal with it. And then if no, then is the instruction going to be, was there anything substantive about the Donovan Thomas murder prior to the motion to recuse? If there really wasn't, then I can say that we're doing everything about that over again. But if there was, then it needs to be a more nuanced instruction. So y'all, I would really like those by tomorrow so that we can discuss them. And okay, because, all right, okay. And then it would be nice to have the 105 proposed limiting instruction by then as well. But I'm certainly not going to give it before I get a proposed one. So that's kind of on you, Mr. Harvey.
And Your Honor,
Yes.
we had addressed in writing and will, if necessary, if the court tells us to address in writing again, that a 105 instruction in a RICO case is not appropriate, but will.
So if you want to you don't have to refile the same thing. Just point me to when and where it was filed. But yes, I know that everything gets to be considered that is alleged as an overt act in furtherance of a conspiracy, a RICO conspiracy and a RICO count. What I am contemplating instructing on is something to the effect of everybody here is charged in count one. Anything you hear that's an overt act can be taken into consideration when considering whether the state has established guilt as to count one, as to each of these individual defendants. With regard to, whatever count it is. If we're talking about the Donovan Thomas murder, that evidence can only be considered as to the people charged with it when determining whatever those counts are, 2, 3, and 4, or whatever they are. So that the jury knows what they are appropriately considering everything against. I want to give a legally appropriate instruction.
Understood.
Okay.
But we did allege the Donovan Thomas murder.
Oh, I know. And so it is 100% appropriate for the jury to consider that evidence when considering count one against each of these defendants. It is not appropriate for them to consider it in terms of the guilt of any of the defendants to any other counts other than the people who are charged with the murder and the corresponding whatever it is, ag assault or gang or whatever. Okay. So that's my thought as to that. And y'all work on, well, Mr. Harvey is going to take the lead on, and then I'll listen to objections on, and I'll formulate something. But I think that that is appropriate upon request, as long as it is an accurate statement of the law. Okay? All right. So that all being said, let's now turn back to the scintillating task of how to redact this statement. Laura, can you make me a copy? Ms. Love, I asked for my stapler back, Mr. Atkins, and it is not back yet. So I may not land it to y'all again.
Yes, Your Honor. Thank you for letting me borrow it, Your Honor.
Okay. All right. Everybody ready on our August 5th, 2015 statement that we need to get through? I'll take the silence as a yes.
Yeah.
Okay. All right. All right. So, Mr. Shard, if you could do us the favor of making your proposed redactions another part of the record somehow.
Would you like me to put like the heading, the title of the case and style of case on it?
I mean,
Make it look official. I didn't file them in, obviously. But-
you know, it can just be a notice of filing, and you can do a cover that says notice of filing of, you know, whatever, and then just attach this. Is
Yes,
fine
Your
with me. I'm not really that particular about how it gets done. I just want it to be a part of the record.
Yes, Your Honor.
Okay, thanks. All right. Item number 1, page 24 is where we start.
So, Your Honor,
Yes,
in regards to the state's position here,
yes.
it is not, we are introducing this kind of like what the court alluded to earlier.
Mhm.
It is important that the YSL members believed it was Ifgang. Whether
Right.
Ifgang actually did the shooting or not, what happens immediately after this is
Okay,
they get in the car and go and do retaliatory shootings.
right.
So it's the fact that they believed it was Ifgang, whether in reality it was or not, which came from Summer Good, who is Quamarvious Zachary's at the time girlfriend.
Okay. Oh, and let me ask, actually, are there any of this list of 43 items that the state agrees should be redacted?
Yes, Your Honor.
Yay. Tell me what those are.
Your Honor, I'm going to it. I know off the top of my head, there's one that references the Sandy Springs search warrant of defendant Williams' house, that's out. I'm trying to figure out what number that is.
Okay. Mr. Sharp, do you happen to know which item number that was? Sandy Springs search warrant? Are there more than that one?
Yes, Your Honor, there are.
Okay.
There's also one where, and I'm finding this number, Your Honor, but there's a line where Mr. Zachary says that defendant Stillwell is hot-headed. There's a part after that, but the state agrees that calling him hot-headed,
Okay.
the state would concede that. So I'm going to I have this in order, but
Okay.
I didn't
So
separately draw out which ones.
it's fine. I guess just then, whenever we get to it,
Yes, Your Honor.
you can say, before I read it and Mr. Short argues, just say, okay, for that one, we agree.
Thank you.
All right.
The first one that Mr. Atkins was referring to is number 34 on my list, I
Okay.
believe, which is page 149, line 19.
Okay.
That's correct, Your Honor. Thank you, Mr. Sharp.
All right. Perfect. Okay. So back to number one then.
Yes, Your Honor. So as articulated, the state's position here is it's important that they believe that Ifgang was who shot at Deamonte at Club Crucial, because after that, Cordarius Zachary, Antonio Sledge, Deamonte Garlington, and defendant Stillwell, they get into a vehicle and go and shoot 1428 Adele Drive, 1903 Drew Drive. And so it's in result of Ifgang shooting at them. So I see the objection is hearsay about who did the shooting at Deamonte at the club. And so the state's position is it's the effect on.
Right. You're not offering it for the truth of whether those people did the shooting. You're offering it for this was what this crowd believed.
Yes, Your Honor.
All right. Any response?
I believe that it's hearsay. Mr. Zachary was not present. I heard what the state said. My stance is Mr. Zachary was not present at the club when Deamonte allegedly got jumped, and he wasn't outside the club when shots were fired. So any information about what happened outside the club that day was something that Mr. Zachary does not have firsthand knowledge of.
All right. And so essentially 24 and 25 relay a lot of, I guess, details about who did the shooting.
Yes,
Yeah.
outside the club earlier that night.
All right. So and again, all of this is if you have to impeach him because he is not testifying as you thought he was going to consistently with these interviews. So if you are then impeaching him, and your purpose is, hey, at that time, you told us, it needs to be phrased in a way that what you're impeaching him on is not A, B, C, and D people committed this. It's you thought at the time it was this, right? And so I don't even know that you need to go through 2 whole pages of that to accomplish that.
Yes, Your Honor.
Okay. All right.
Understood. And agree that's the state's intent with this portion.
Okay. And y'all, I'm making all of these rulings prior to us coming back with these witnesses on the stand in hopes of there being an understanding by everybody what comes in and what goes out and us not having to take it up while the jury's here. But if for anything, at the time we arrive at it, it looks like, okay, this is not what we agreed to, or this was not my understanding, don't just sit mute. I mean, raise it to me and say, remember, Judge, you said it He didn't need to get into all of these details. It was for the purpose of, y'all believed at this time it was IF, okay? Y'all are on notice of that, okay. All right,
So, Your Honor.
yes.
The second one, this transcript is very incomplete. So
Yeah,
could I mean, I'm sure Your Honor can flip to the page, but it's probably not going to help. May I convey what I believe?
absolutely. And that has been helpful to the extent that both of y'all, both sides have done that so far. And from the portions that I have listened to with the transcript in front of me, watching the videos, yeah, I mean, the transcription is less than stellar. So yes, please do. Please continue to do that.
So on page 48, line 7, Quindarius Zachary says, and he and Thug, like, nah, I ain't cool with N's, the N-word, until they pay for my window.
Okay. Until they pay for my window.
And then it says woman, and I believe that's Investigator Gaither says, but why they shoot up the dugout? And then Mr. Zachary, Woody and Cal had something personal going on, I guess, who was big and bad. And my objection is with the statement that Mr. Williams, according to Mr. Zachary, said, nah, I ain't cool with N-words until they pay for my window.
Okay.
I don't have any understanding or belief that Mr. Zachary had any firsthand knowledge of any conversations that Mr. Williams may or may not have had with other individuals about this subject. And I think he's just passing on information that he's heard.
Your Honor,
Mm-hmm.
the state's response here. So just to give a little context to Zachary at this gambling house, Zachary says, I was inside. I didn't have a gun on me that night. And the way he says it in the state's opinion is that when defendant Williams walks outside right before who they later go on to believe Kelvin Watts, Shell Kell shot and broke his window, that he kind of comes outside afterwards. I mean,
He's Zachary?
Yeah, Zachary's inside when the shooting happens. So he's not physically outside. He doesn't like spot Shell Kell in the bushes and say, oh, I saw him with my own eyes. But it's kind of the state's, with the way he describes it, you know, he walks outside soon thereafter because he just heard a bunch of gunshots. Right. And I think it's reasonable to believe that, you know, they would all be discussing, and he kind of alludes to that, like going to the parking lot and there's a lot of broken glass and bullets. They don't immediately know it's Kelvin Watts, but at the same time, the state believes that between either excited utterances of people out in the parking lot after this shooting that hit multiple cars and or speaking with fellow co-conspirators, what he says here, and this is relation to something else that comes up down the road where a female who Shell Kell ends up confiding in, Zachary classifies it as flexing, like bragging about doing the shooting. Right. That's how they end up believing or thinking that he did that, to confirm that. So when he says here, you know, he's explaining about defendant Williams' reaction to the window being broke, I think there's reasonable assumptions, I believe, that given his personal being there, interacting with these individuals on a regular basis, and also the key part that Kelvin Watts is the half-brother of the deceased Donovan Thomas. And so I'm not saying that the murder of Donovan Thomas was 100% related to this broken window, but it is, you know, relevant in that sequence of events and escalation of shootings in the state's position. So with all of that said, the state feels that this is not as speculative as it may first seem.
All right. And you've got evidence somewhere else that Zachary walks outside while the, you know, aftermath of it is still going on?
In this interview, Your Honor, he ends up saying, so everybody's walking him to the car, him being defendant Williams, then here's gunshots still going off. And so he says, I'm still gambling. I didn't have a gun anyway on me. So no sense walking him out there. So Zachary tells the police in this same interview, I was at the gambling house. And then he says, then gunshots go off and then everyone runs out the door. Everyone in there with guns ran out, started shooting. So like he kind of alludes to after this gunshot, everyone in the house ran outside. To include
Everyone,
himself.
if he says everyone with guns ran out, that does not include himself.
Yeah.
If he just said he didn't have a gun. So is there something more?
So, Your Honor, he also goes on to state that a bunch of people were, he's inside the gambling house. He said he posted a bunch of pictures, Instagram photos, and he says, when the windshield got shot out, did they confront Kell about it immediately? And Zachary says he didn't know because they didn't initially know. They have to find out down the road. And so I'm trying to find where this is in terms of, he says, you all come outside. Zachary says, I didn't have a gun. And so there's other, I guess, evidence, so to speak, of in some of Copeland's interviews, taking aside what's in evidence right now or not with what we're redacting, he describes this gambling house incident as well. And so for purposes of in this hypothetical universe, you know, defendant or not defendant, but Mr. Zachary is going to testify after Copeland.
Okay.
And so the state believes that with the combination of, you know, I can't find in this moment, Your Honor, where Zachary himself walks outside, but he does state in this interview that there was a lot of gunshots. It was chaotic. People ran outside. I think it's fair to assume he walked outside at some point shortly thereafter, didn't just stay gambling after they shot up. And he interacts with these people on a nearly daily basis or a frequent basis, that this shooting of the window is something that gets referenced by multiple interviews.
Yeah.
So it's the state's position. I don't have like a definitive piece of evidence where he's like, this is exactly how I know, but I think it's reasonable to think that he would have a pretty good basis for what he says in this specific clip that we're arguing about. And also, you know, when he says a part of this as well is Woody and Kell had something personal going on, he interacts with Mr. Copeland, who his nickname is Woody. And so I think he would have a foundation to know that Kenneth Copeland and Shell Kell did not interact well.
And I'm not even honestly sure that when he's saying that Thug says, no, I'm not cool with them until they pay for my window, that he's necessarily, that the assertion is necessarily that is what Mr. Williams voiced to anybody that night out in the parking lot. It's just.
So my understanding, based on what Mr. Copeland has stated in this courtroom, whether it's in the evidence right now or not, there's a shooting at the gambling house. Shell Kell was not initially thought to be the person, and then later has pillow talk, and he's thought to be the person. I agree that Mr. Zachary was present at the gambling house per his own words, but this conversation about I'm not cool with people until they pay for my window never is alleged to have happened that night. There's a subsequent conversation with Mr. Copeland, and Mr. Copeland is apparently there, and Mr. Watts is apparently there, and allegedly Mr. Williams is on the phone with Mr. Copeland. That's Mr. Copeland's testimony. Mr. Zachary, to my understanding, has nothing to do with that conversation. So he's just passing on hearsay that he would have heard from Mr. Copeland, presumably, but that's, I'm speculating.
Okay, well, even if it's hearsay, I think this would come in under the, what's your theory as to why this comes in? If he hasn't heard, I mean, if you can show that he at some point heard or overheard Mr. Williams saying, they can pay for my window and then we're cool, not until then, great.
Yes, Your Honor.
Point that out. Otherwise, it is hearsay. What would the exception be?
So, Your Honor, the exception here would be, or at least the state's argument is that, and I can't directly point to the moment in time where he believes or hears someone state, I'm not going to be cool with him until he pays for my window. What I will point out, and I will, in answering the court's question, is shortly thereafter, in this interview, Mr. Zachary says, Thug comes in crucial, throws money. Kel doesn't want him to do that. The Thug, he's not clicked with him, or it may be cool with him. He didn't like them. They shot at his window. So he later on in this interview states it definitively that like he doesn't like them. They shot at his window.
Okay.
And so the state's position is that for an exception, and again, I don't have direct evidence of which individual told him this, but the state's just given this event of the window being broken, repeatedly being brought up by either defendants or co-conspirators in relation to this, and it being a somewhat significant event that it's reasonable to believe that this is either a co-conspirator statement that was made or something that he has a good faith basis to believe that defendant Williams does not like Kel because he, and what ends up, what Mr. Copeland says on that is basically Kel's like, I'm not paying for the window. And so it kind of ends on that note.
Yeah.
So I don't have a
Okay.
definitive moment in time, but that's the state's position on that in terms of Zachary making that
All
statement.
right. Okay. I mean, yeah, I would think that this could come in under 801D2, maybe E or yeah. Yeah. Or A, really. Okay, so that is going to be admitted over objection.
Boone.
Yes.
Number 3, Your Honor, is Mr. Atkins kind of leads us to number 3, which is the conversation that he just referenced. Mr. Zachary, and you don't get this from the transcript, but he says, I'll start in the top of page 49. Zachary says, you know how they do, Kel wasn't like Thug coming crucial, giving out, throwing stuff. Kel didn't want them to do that. And then Gaither says, right. And then Mr. Zachary says, yeah, Thug wasn't, he ain't click with them like he didn't like them. And then Gaither says, he ain't like Kel shot out his windshield. And then Zachary says they shot out his window. My objection to this is that he's testifying to the thoughts and feelings of Mr. Williams, who Mr. Williams likes, who he doesn't like, and to the mind state of Mr. Williams. I don't believe that that's appropriate.
All right, so the throwing money parts as to the incident that happened at the club,
Correct.
right? Where some people,
And for context.
right. So I mean, is Mr. Zachary there, or does he know about that incident having occurred?
So, Your Honor, there is there's specific incident reference where Mr. Copeland gets jumped at that nightclub after flashing money. But in Mr. Copeland's own, and maybe in other statements, but certainly Mr. Copeland, he kind of regularly went to Club Crucial and flashed money.
Okay.
And so they kind of referenced that Woody flashing money in Club Crucial was not like a one-off event.
Right.
And so the way I take some of this, what he's saying is, they come into Club Crucial almost every Monday or every other Monday or frequently, like to come to that same establishment where a lot of Shell Kel and his crew, which is the If Gang, and the YSL are there at the same time. So with that, I just wanted to clarify that for the court.
So who's the he that we're talking about then in 49, 1 through, I don't know, 8 or 9, where there's a he didn't want me doing that, he ain't clicking on me.
They're talking about defendant Williams, like,
That's what I thought.
yes, Your Honor.
He ain't clicking with them,
With,
the opposite side as
okay,
well.
well, I mean, So that's just mistranscribed.
Yes, I believe so.
Okay. I mean, okay, so y'all are going to or have established that Mr. Zachary also has a close relationship with Mr. Williams, right?
Yes, Your Honor.
Okay, I mean, he's got a basis to know those things. So overruled.
I'm going to withdraw number 4.
Okay.
After consulting with my colleagues, we're going to withdraw number 5.
Okay.
Okay. All right. Number 6, Your Honor, is talking about, and this came up in I think the last statement as well. They were under the belief that MBC did the shooting at the dugout, the false belief, and they're talking about why did you believe that? And he's saying because Yak, Mr. Kendricks, beat up someone at the club. And specifically on 55 line 17, if I can make sense of this transcript, they said they didn't mess with each other. They didn't mess with each other. So it was already tension in the air, but they waited until the boy Yak, he had gotten into it with MDC, and I had helped him fighting in the club. So y'all got into it, some guys with MDC. MDC is down with who? They from Bankhead. And then they say, so Ms. Gaither investigate. That's what I'm saying. It's like they not really with. And then Mr. Zachary says, if gang, and Gaither says it's just them themselves.
Okay.
So this has nothing to do with.
All right.
It's just bringing up a fight that Mr. Kendricks apparently got into, allegedly, that led to the mistaken belief that MDC was behind the shooting of the dugout.
All right.
So, Your Honor, the state's position with this part is it has a couple relevant portions. One being state has to prove association. And the fact that Zachary is defending, he's like, I get in the fight too with the MDC, which is the most dangerous clique, a gang on the west side in Bankhead at that time. The state's not going to be belaboring the point about this one fight and trying to cast anything improper, characterize or what about a fist fight in a club. But the point of this is that they defend each other. And that's a big part of the retaliatory shootings. This is a fist fight, but the fact that he jumps in and protects them, and also the way he describes this in the state's position is, he says, like Detective Gaither, Zachary's like, they're from Bankhead. And Detective Gaither's like, that's what I'm saying. They're not really with If Gang. And Zachary says they're just their self, like they're not a part. So he has some familiarity with street gangs and who is clicked up, so to speak, with who. And so the fact that he's talking about and he's saying like to me, there's a we and an us. There's not a lot of, there's not much else that I've seen in this case law about MDC, but that part is important.
Okay.
Another part about it that's contained in this, I believe, is this gets down the road to where how they learned that Shellkel was the one who claimed or did shoot defendant Williams' window. And so he says he ran his mouth to a female who goes by Gucci Red. And so again, the key part of this is that's how they end up believing that Kelvin Watts did the shooting, because they initially thought it was MDC because of this fight. So The state believes this portion is relevant for a number of reasons of why they initially thought it was MDC, the association between Zachary and Kendrick's, and also there's a part, at least if I'm reading the page 55, line 17 to page 57, line 7. My apologies, Ms. Madam. To page 57, line 7 includes what on its face seems hearsay. Like they learned about this from this female, but it's again, it's important that they believe it was Shell Kell who shot the window.
And I think we've made the decision as a defense that we're not going to fight the hearsay about it being Shell Kell and how that eventually came about. And that would be on page 56, line 10 to 19. He's saying that they found out it was Shell Kell because he was running his mouth to Gucci Red. He says pillow talk and junk. So I don't have a problem with that section. I just don't know why we need to get into Mr. Kendrick's apparent simmering feud with completely unrelated people that led to the false belief that it was the most dangerous clique as opposed to Shell Kell. I mean, we can just get into the fact that they know it was Shell Kell now without going through that whole misapprehension.
Okay, so, I mean, it is potentially relevant. And again, this is only if he testifies inconsistently on the issues of, as you represented, what you think it's important for is that, hey, we all defend each other. We hear XYZ, and then that's good enough for us. We go back our boys. And what was the other thing you said? I mean, I think it can come in for that. And then, as to, they've withdrawn the objection to how they end up finding out it's somebody else. So, okay. And so again, as I said with regard to the very first one, this does not mean that you then have license to play these whole 3 pages. You just need to make the point in the part that would make that point, okay?
Understood, Your
All
Honor.
right. Okay. So turn into item 7 on page 59.
This is them talking about the dugout shooting and them finding out it was Shell Kell. So I'm going to withdraw that.
All right. All right, item 8 is bottom of 60 through middle of 64.
Okay.
And give me just a second to take a look through that.
I forwarded it to you. All right, hold on. Just sent it.
Your Honor, this may be a portion that if the court has any questions, listening to it may be of assistance because there is some
There's a lot.
scrivener's errors a lot in this portion.
Okay. Do you have it queued up?
I am, Your Honor. We're
right.
getting queued up right now to play.
As a general proposition, this is my understanding of what Mr. Zachary is saying.
Speak into your mic.
Mr. Zachary is saying throughout this process that my client told him some information.
Okay.
That information included 4 people that were in the car. That's what Mr. Zachary is saying. Mr. Zachary is also saying that Mr. Kendricks said something to him, which was that involved the 4 people in the car, according to Mr. Zachary. Later on, he goes into more detail, and this is starting on 63 line 8. He goes into more detail about an entire story involving cars and cars driving by the Texaco and spotting Donovan Thomas and switching seats with Bushi and all those things. My understanding is Mr. Zachary is saying his source of knowledge on that is Mr. Garlington.
Okay.
So my objection is that anything that didn't come from my client would not, I understand statements by a party opponent as it applies to my client. If he's saying my client said something to him, I understand that, and I'll deal with that through cross-examination. But regarding things that Mr. Kendrick supposedly said to Mr. Zachary, or that Mr. Garlington supposedly said to Mr. Zachary, I'm objecting as on hearsay and confrontation clause grounds.
All right.
Your Honor, just to kind of give the court the state's position, there's no confrontation clause issue because it's not testimonial, but to go to, so the way, and we'll play this, before he gets into this portion, they ask him, who told you? He says, Shannon and Yak is defendant Kendricks.
Okay.
And then he just kind of goes into after that, they're like, why'd they tell you? We were at the house talking about it. And for the next, couple minutes, he just starts providing details. So it's not exactly clear.
Right.
But also what's important, Your Honor, is he also later on in this interview, and there's some social media that backs this up, that Mr. Zachary, defendant Stillwell, Kenneth Copeland, Demise McMullen, who they call Nard, defendant Williams, they go in a Sprinter van down to Miami, Florida.
Right.
So they have some statements about defendant Williams had a concert there. The state also believes use it as some consciousness of guilt getting out of the city after the murder, because Donovan Thomas is January 10th, and they start traveling down there January 11th. And so all that aside, the state feels that him, the night of the murder at defendant Williams' condo, them directly telling him, obviously that's a party opponent admission, but the state feels more so it's a co-conspirator statement to keep him abreast. They all travel together as a group down there. And then, so that's the state's position, is that this entire portion is a co-conspirator statement. It's keeping them abreast. It's cohesive. And he needs to be aware, because what happens that same night is if gang members and their associates start shooting YSL houses up. And that obviously escalates.
All right. And I think that my ruling with regard to this piece of the statement is the same as it was with regard to the similar statements in the April 2017 interview or statement. And that is that these are statements by a co-conspirator, and I believe sufficient evidence that they're during the, in furtherance of the conspiracy and still in the concealment phase. So I'm going to admit those over that objection. And with regard to the confrontation clause objection, these are not testimonial as made to Mr. Zachary. Okay. So item 9.
Item
Yeah.
9 honestly would fall under the same
Same, okay,
ruling that you just.
all right, thank you. So item 10 is on page 66.
Your Honor, I believe this is just a single line of Detective Gaither asked Zachary, did Woody, Mr. Copeland, have anything to do with not being killed? And he says, nah. And the state, it's listed as speculation.
And based on the fact that everybody's there right after the murder talking about it.
Correct, Your Honor.
Okay, all right. On that basis, I would permit that. All right. Item 11 is 60, bottom of 66 through mid 69. An objection is hearsay. Is this going to be the same concept or something different?
It is.
Same.
But within it, so I will, over my objection, I understand.
Yes, and I understand you still have an objection to it, but
Now, I will point out on page 67, line 18, they say, why not? And Mr. Zachary says, I don't know, they just like, I guess they just wanted for them to do it instead of Moontook and Woody. So he's speculating.
all right, let's strike 18 and 19.
And that page.
Page 67, 18, and 19 is speculation.
And then Gaither follows up like they wanted to do it themselves.
Oh, okay, so 18 through 25, really, right?
Well, and then he says not to get them a name. He's speculating as the reason why they just wanted to get a name for themselves.
Okay,
All
right, so-
I'm looking at my notes. Line 2 on page 68 says like to get them a name.
okay. Okay, well, yeah, that's also speculation, unless you have some basis for it being something other than that.
So, Your Honor, the state's argument on this part, this portion is when he's talking about getting a name,
Mhm.
it's very integral from the state's position of how gangs work in terms of trying to move up in rank.
Yeah.
Later on talks about like, so the state believes that his quite frequent interaction, he does state it speculatively. I'll be upfront with the court about that, but I do believe that in terms of they ask him why, and the court may say, hey, Mr. Atkins, it's speculation, it's out. But my argument on this is that his frequent interactions and, there's evidence that will come out either through impeachment or some other way that he has participated in crimes with them
Okay.
and is familiar with who he's speaking about. His thought process on motivations or what was going on in terms of like a gang context is appropriate. That's the state's argument.
All right.
Now, I believe the state has, I know that they've called experts, and I believe the experts have touched upon people, quote unquote, the term that the experts like to use is putting in work. And they've talked about that.
All right.
The state, I'm sure, is going to argue that. So I'm not saying that, obviously they can do that, but they can make that argument. But for Mr. Zachary to affirmatively say that's why other people did
Yeah,
something.
sure. Okay. Let me make a ruling with regard to 67, 18 through 68, 2, that if you cannot get this in as speculation as to why XYZ people might have done this murder. But what you can do is if you ask Mr. Zachary, is a way for people to move up in a gang to commit crimes, and he says no, then you can ask him about that particular concept and him having said before, well, Not with regard to a specific crime, but you're being asked about a crime and you're saying, well, maybe it was to, okay, understand, everybody understand?
Understood, Your Honor.
All right. Let me write myself a note on that. And the rest of it, if the rest of it is just kind of the same basis of knowledge, co-conspirator thing, or is there more to it than that?
More to it than that.
Okay.
So for the rest of 68 to 69, line 11, it's discussion. I don't know if you've heard us talk about this yet in this case, Your Honor, but part of the story in this case is that there was a meeting where Mr. Thomas, or there was a gentleman that, according to the story, that I believe Mr. Copeland has given, there was a gentleman in prison who was affiliated with If Gang.
Okay.
And through consultation with that gentleman and other people at this meeting, which Mr. Zachary was not at, Mr. Thomas and others ratified a quote unquote green light to kill YSL members. Or no, I'm sorry, let me not misspeak, to kill Kenneth Copeland.
Okay.
And so Mr. Zachary is talking about hearsay that he's heard about this green light that was put on. I don't think he specifies in this, but in other statements, it's said to be Kenneth Copeland, I believe, but he doesn't specify. He just says he put a green light on line 10 on page 68. It says, cause they said a powwow, and like green light, all YSL and 30 deep. They say nut said whoop or something like that, meaning it's a go. So he's saying they said that Nut did this and Nut did that to say it's a go to kill YSL members or 30 deep. That's Mr. Zachary's statement, but Mr. Zachary wasn't there, and he's saying they say that this is what Nut did.
Okay.
So, Your Honor, the state feels this has a huge effect on listener and also is classic co-conspirator statement in this context. And I'm trying to remember exactly where this is. I believe it's Mr. Garlington who tells, basically it's either Mr. Garlington or Mr. Copeland who gets information from this meeting. And that's why when Zachary says, like from my notes of what he says, so Detective Gaither says, so you're saying If Gang had a powwow? And Zachary's like at the house, at their spot on MLK. So he's talking about like a specific location that came from, I believe it was Mr. Garlington, but that's just off memory, Your Honor. And then Detective Gaither says, okay, and they say that YSL and 30 deep. Yes, my apologies. As the court has said, when we read, we get fast. So in 30 deep got a green light, which basically means you kill them if you see them like they're food. And then Zachary says, yes. And so that is important for a number of reasons in terms of whether If Gang members actually said, yes, YSL is on the plate, so to speak. You can shoot them, kill them, attack them whenever you see them. The fact that Zachary is stating that YSL members, to include himself, believe that was true, that is critically important for the effect it has on them.
All right. And you're saying that one of the other alleged gang members who's indicted in, or maybe has fled or not, but is indicted, actually has a basis of knowledge for what went on in this powwow. And is that what you said?
Yes, Your Honor. And my memory is either Mr. Garlington was actually, he either was there or someone at the meeting who was friendly, because Mr. Garlington was 30 deep at some point in time. And there's some friend, like people, it bleeds over. It's not like
right.
You have friends in other gangs, so to speak, or associates. And so someone calls and notifies either Mr. Copeland or maybe it's Mr. Garland who calls them. That's what my memory is of how this got to there.
Y'all have evidence of that you're intending to introduce? Or you have a good faith basis for saying he had a reason for knowing this?
Yes, Your Honor, and I will find where that
All
is,
right.
what interview statement, but yes.
Okay, well, I mean, assuming, go ahead.
It's my understanding, it's Mr. Copeland that introduces this concept.
Okay.
I don't believe Mr. Copeland was at this meeting either. It's entirely unclear to me, and I may just be misremembering, but I don't believe it's ever established exactly how Mr. Copeland knows. But Mr. Copeland is
Okay.
other person that spoke about this, not
All right.
Mr. Garlington.
But Mr. Copeland relays to,
Well, I don't know. We don't know that.
well, he knows it somehow.
Well, I agree that he is passing along information.
He could be correct or not about it, about what happened in the powwow, but at this point,
There's no evidence that I'm not trying to be hyper technical, but when we're talking about statements made by a co-conspirator and furtherance of a conspiracy, there's no evidence that Mr. Copeland told Mr. Zachary this.
okay, but as I understand the state's position, they're not offering this for the truth of what happened in the powwow. They're offering it to show that the alleged YSL gang believed that it was, open season on them, and that had been authorized by the IF gang. So that is permissible for that purpose. It's not hearsay at all. Okay.
Your Honor,
Yes.
and this is something that's probably going to come up later. There may be times if they're not offering these things for the truth of the matter asserted, that we have to give the jury 105 instructions regarding exactly what the purpose of the evidence is.
All right. And I would expect you all on the defense side of the room to make sure that you timely alert me to that fact before any testimony like this or cross impeachment like this comes out, because that instruction is supposed to be given prior to the jury hearing that evidence that's only offered for a limited purpose. So y'all are on notice that you need to let me know of that. If you forget, then I can always notify them later, but you still have to raise that to me as well.
Yes, Your Honor.
All right. Thank you. Okay, we can probably knock out a couple more of these before we wrap for the day. So item 12, which is bottom of 70 through most of 71.
Yes, Your Honor. So
This would fall under your rulings about Mr. Garlington.
Okay. All right. Then that would be in if that's the only objection. All right. All right, now we're moving to page 81.
So, Your Honor, my notes or what's said here says, Zachary says Nard says that Woody's going to fold, talking about Mr. Copeland.
Okay.
I'm like, what do you mean? I may have started this a little bit before, but I wanted to read, it's just two sentences. And he says, I'm like, what do you mean? He's going to tell on us. I'm like, about what? About the nut situation. He won't fold. And then he says, that's why Thug stopped messing with him, because thought he was going to fold.
I agree with the content.
Okay.
And my objection is to the speculation and explanation of what's going on in Mr. Williams' head. That's why Thug stopped messing with him. They thought he was going to fold. That is the part that I object to, which doesn't come across clearly on the transcript.
Okay. So this is who talking to whom?
So this is,
I was like, what you mean? Blah, blah, blah. Who's having this conversation?
So Mr. Zachary first is mentioning a conversation he had with Demise McMullen, who told him that he believed Mr. Copeland was going to fold. And
Okay.
then Zachary also states, I think Zachary actually then, after he says Nard thought Mr. Copeland was going to fold, he thought he was going to tell on us. I think Zachary just starts saying that's why Thug stopped messing with him, because he thought he was going to fold.
I think he says first, Mr. Zachary says, I don't think he's going to fold.
Right.
He was responding to Mr. McMullen.
I didn't think he was going to fold. And then I thought,
Then he says, that's why Thug stopped messing with him.
okay,
Thought he was going to fold. And that's the part I'm objecting.
okay.
And the state's position is that Zachary's has enough foundation to know what his fellow co-conspirators' viewpoints are, especially on someone snitching against them, which is of peril to individual defendants and also the gang writ large, for obvious reasons. And so the fact that this conversation is all about someone telling on other members of the gang and individuals, Zachary would have knowledge of how they would view that and why they distance themselves from Mr. Copeland. And so the state feels that he has relevant personal knowledge from interacting with defendant Williams and seeing the interactions with Mr. Copeland starting to go down,
Okay.
as in not as frequent as they used to be.
All right. So and your basis for this not being speculation is that you think that, let me just say this, before you could get this in, you need to establish the foundation for him knowing. I mean, he can know by observing that Ms. Williams and Mr. Copeland kind of stopped seeing each other so much. But if you want to impeach him on why, then you need to establish that he actually had a basis for knowing the why. Okay.
Understood.
Okay.
The next one is the one that the state, at least a portion, agrees with Mr. Sharp.
Okay.
So that line that says, yes, Shannon's hot-headed, the state agrees that
Yeah,
that should come
okay.
out.
How about him? All they want names for themselves. That's all they want, names for themselves.
And this is similar to the court's earlier ruling where I had asked about moving up in rank. So
Okay. So you could use this as well to say, didn't you tell us already? They want names for themselves,
yes, Your Honor.
but only for that. And the hot-headed part doesn't come in regardless.
Yes, Your Honor.
All right.
And then
Hang on. Give me just a second to jot myself a note. 122. So I don't know what the line 25 and then the response on the next page is about.
The-
That seemed to be included in your objection.
right. So the investigator says, so Shannon, don't give a F word. And then Mr. Zachary says, oh, hell no. So that I object to that as well.
Okay. So that's just,
I will concede that, Your Honor. I skipped past that.
Okay.
Yes. We will not be asking something about those two.
okay.
Your Honor, the next one, it says, Mr. Sharp says irrelevant discussion of Bentley selling
Right.
drugs. Bentley being OG Bentley, who's Kelvin Treadwell.
Right.
And so I wanted to read, because I think it's a little bit cleaner, what's said in this portion. So I have Detective Gaither says the guns possibly on Bentley's spot.
Hang on, let me figure out where
Yes,
you
Your
are.
Honor.
So this is
82.
83, right? Are we back on 82?
I might have had a typo. I had page 82, line 25.
It's 80,
83, line 25.
83, line 25 is, so that was what you were reading though, Mr. Atkins. The guns possibly at Bentley's spot on Oak Drive. That's the beginning. That's before I object.
Okay. Thank you, Mr. Sharp.
All right.
And then Mr. Zachary says, yeah, so they're talking about Bentley's spot on Oak
Okay.
Drive with the
Mhm.
guns, but
Yep.
then they move into selling drugs.
All right. Yep.
And Your Honor, the state's position of why this is relevant is that on page 12 of the preamble to the indictment, the state sets forth that part of the purpose of the RICO enterprise is the sale and distribution of drugs. Furthermore, there is in both Mr. Copeland and in Mr. Zachary's statements, they speak and reference that after the murder of Donovan Thomas, OG Bentley basically had like a spot, either a trap house, a drug spot, something
Right.
where he on Oak Drive. And so when he says, so Gaither asked the guns possibly on Bentley's spot on Oak Drive, that's what she's referring to. And then she's like, what kind of drugs does he sell? And Zachary kind of goes into detail, dope, crack hard. And she's like, nickel and dime are rolling in it. And Zachary's like, both. And so for one, it's relevant for Zachary to have knowledge of one of, even though Treadwell was not indicted, the state's position in Detective Gaither and Detective Dennis' testimony through an earlier act where his vehicle was used to do an attempted murder of Dexter Montgomery, which was Act 36. It's very relevant, Zachary's knowledge of Kevin Treadwell dealing drugs. And the state has to prove the existence of both the criminal street gang and the RICO enterprise, which are sort of part and parcel of the same. And so the state just feels that this is very relevant, given there's also a number of drug charges on this indictment.
Right.
So it goes to count one, the RICO is the state's position.
And Your Honor, nothing I'm trying to keep out finishes Mr. Zachary's alleged knowledge of Mr. Treadwell's house or whatever it is on Oak Drive. I mean, he's clearly saying it's Bentley's spot in Oak Drive before we get to the part that I
Right.
want to take out.
So do you just not want it said that he sells crack?
All the drugs. And this is why, Your Honor, Mr. Treadwell is not indicted on this case.
Right.
Nothing involving Mr. Treadwell selling drugs is listed as an overt act at all in count one. So we're just throwing in an associate. And there's no indication from this that Mr. Treadwell somehow kicks back money to Mr. Stillwell or Mr. Williams or anyone
Okay.
else. It's just Mr. Treadwell, who is associated with us through evidence that we know him. I think that evidence has come out that he's Mr. Williams' road manager at one point
Okay.
in his early in his career. But I don't know why we would get into his
Okay.
unrelated
Yeah.
criminality.
All right. So if he's not an unindicted co-conspirator, if he's just an associate and there's no evidence that YSL is in any way benefiting from this guy Bentley selling drugs, seems like Mr. Sharp's got a good argument here.
So, Your Honor, on the first point, and this was the act I was referencing, but just to give a little more clarity, there's individuals at a gas station, they think someone's trying to rob them because they're coming up close. And he calls Walter Murphy, who is a defendant who's pled, and Demise McMullen to come over and shoot with a stick, and they shoot and take off half of Dexter Montgomery's head. Kevin Treadwell, he's the he.
Okay.
Makes the call.
Bentley, Kevin Treadwell is the one who makes the call. And then these alleged YSL gang members come to protect him and his drugs.
Yes, Your Honor. And that's in regards to him being like, is he an associate, a member? The Detective Dennis and Gaither would classify Kevin Treadwell as a YSL gang member.
Okay.
Now, in regards to the drug proceeds, I do not have any evidence that some receipt or some conversation of I'm paying my weekly dues to the YSL gang from this drugs that I sell at my trap spot. I don't have that kind of evidence. But the state, so I wanted to answer the court's question.
And in that incident, there was no evidence that these gentlemen were called to protect Mr. Treadwell's drugs. The state, I think, characterized it as just a senseless act. We were categorizing it as Mr. Treadwell believed that Mr. Montgomery and his associates were attempting to rob them outside of the gas station. But at that incident, there's nothing about drugs.
All right, unless you got more than that, Mr. Atkins, I don't think that this particular part, which is 8325 through 8410, comes in.
One small request.
You may.
There's a part, and I need to get the line of it, where he says, Detective Gaither asked him, does he still drive that white Nitro? And Zachary says, nah, he let Nard F that up.
Okay.
I would like that part in because that white Nitro.
All right, that is not a part that is objected to, that's being excluded.
That's line 12 on page 84.
Thank you.
All right, sure. All right. 85, line 13 through 8611.
So context here, Your Honor. Mr. Treadwell is actually, at the time, I don't think they're still together, was actually in a long-term relationship and has a child with Donovan Thomas's sister.
Okay.
And so this is all a discussion about, there's a lot of speculation about what Donovan Thomas' sister knows and how she feels about this and how she feels about Mr. Treadwell, which I don't think is relevant.
Your Honor, the main portion of this, so to speak, that the state wanted in is not as much about what his wife knows. It's more so this line where he says she doesn't know that he, talking about Kevin Treadwell, hid those guns and had something to do with it, talking about the murder of her brother. And so.
Where is that?
I will find the line.
That's 86 line 1. In the part unintelligible, I have, she don't know he had something to do with it.
Okay.
And he's already laid out in the statements that I've objected to, but Your Honor has overruled my objection about what, this is all based, he had something to do with it, is all based, from my understanding, is pretty clear. Mr. Zachary is saying that's based on what Mr. Garlington said to him, and that's been repeated several times throughout these statements already about Mr. Bentley getting, Mr. Treadwell allegedly getting rid of the guns. So I don't know why we would need to get into this conversation about what she knows and just for that information, because it's already been provided.
Your Honor, one other small piece is I don't remember when this question was asked or who was asked of, but Donovan Thomas Sr. testified. And there was some questions about, the state asked questions about relationship, family members to give context for the jury. And so there was some questions, I believe, on cross-examination of Mr. Thomas kind of highlighting that Kevin Treadwell's wife is related to Donovan Thomas, because obviously that would cut, this is my idea of why defense would highlight that would cut against their family. Why would he be involved with the murder of his wife's brother? And so, but the state feels that discussing that, because of some of that testimony, this isn't going to be a huge part of our direct questioning of Mr. Zachary, but that is another reason why it is more relevant than it may otherwise be that she didn't know. Zachary's saying she didn't know. Because obviously it would be very odd if she did.
Okay. So then most of 84 and 85 is admittedly not anything y'all would need?
Yes, Your Honor.
Okay, so then if it becomes, if, you know, part of 85 and top of 86 becomes relevant, I mean, it's still like Zachary saying, I don't think she knew, right? I mean.
Yes, Your Honor, and I don't think we're going to be asking specific questions to try to, about this. It was the topic about, you know, her just, well, it may never come up in our
All right.
direct attack.
How about if you think it's going to, you raise it with me and
Yes, Your
we'll
Honor.
hash it out then.
Yes, Your Honor.
All right. All right, 92, first couple of lines.
So, Your Honor, I have, and Mr. Sharp, you tell me if you have something different. I have Detective Dennis says, what he thought get you down there? What was Thug like? Zachary says he's normal. Detective Dennis says he doesn't give an F. And then Zachary says, he's like, why the hell did they kill Nut? That's when I guess they told him. Nut said it's a go. And then he says, Woody, talking about Mr. Copeland, is holding back stuff. He's kind of alluding to Mr. Copeland has friends. He knows a lot of people. So sometimes they're saying Mr. Copeland doesn't state everything with them.
I'm going to withdraw my objection.
Okay. And man, y'all weren't kidding about the transcription being less than 100% accurate. Okay. It is not this court reporter or my prior court reporter. I do not have any idea who this state used, but
I will not
maybe
disparage them on the record, Your Honor.
like entirely off the record. Maybe next time y'all have a bunch of stuff transcribed, you give them like a list of key terms and names of people, and that would help them out a lot. Okay, anyway, totally irrelevant, but okay, so
In
yeah.
light of my review of the transcripts, I'm going to withdraw my objection on number 18
Also, okay.
because I believe that, not saying it's the truth, but I believe Mr. Zachary was there.
Okay. All right. Then we are at number 19, 102, 15 through 22.
And Your Honor, this is one of those ones that the state agrees. This is just a line with Detective Dennis speaking about basically the streets
All right.
convicting Kenneth Copeland.
So y'all concede that one.
Yes, Your Honor.
Agree, redacted by agreement. Okay. 104, middle of 104 to middle of 105.
Your Honor, this is another one that we will concede. Its relevance is very limited. and
Okay.
So
Thank you.
I will agree on this.
Okay. All right, that takes us to page 108.
Your Honor, this came up in the 2017 interview. This is in relation to who shot Mr. Bennett, wife and Lucci's mother's house. I wanted to point out, because this did not come in, this part, in the 2017 interview to my knowledge, but in the part of this interview, which I have begins around on the evidence reviewer time hacks 30850, Detective Dennis says, let's get to this. Who shot up Lucci's mother's house?
Okay.
And there's a little bit of back and forth. And then Zachary says, I'm telling you all if you work with me. And he says, Woody, Shannon, and Little Pokey. And then they ask him like who these people are, and he's like, Little Pokey is Thug's nephew. And this is where the part I think is important for his knowledge of this. Gaither says the gun that you had that you got caught with, she's telling him about the ballistics from the gun that Zachary's arrested with, comes back to one of, because there was 2 shootings of this house.
Uh-huh.
And Zachary's like, well, that was Moontunk's gun, who is Antonio Sledge. And so he's talking about how did Woody get that gun that day? Because Zachary's like, the people who did it was Woody, Shannon, and Little Pokey. And so this is why I think it's important. Zachary says, we were at Big Boo's grandmother's house, and Mr. Copeland's like, hey, let's ride. They leave, and they come back in a white Charger, which I believe is Mr. Copeland's brother's car. And then Big Boo, who was kind of a lot of people looked up to him. He had a lot of money in that neighborhood.
Okay.
And so people would call him to settle disagreements, basically. And so he gets a call from someone in Lucci's, like an associate or friend, who's like, hey, whoever just did that, I got $10,000 on their head because you just shot at his mother's house.
Okay.
And so what Zachary states is while he's at Big Boo's house, Woody and them come back while this phone call happens. And he says, Woody comes in, and Woody's like, what happened? He act like somebody just shot up Lucci's mother's house. And then Big Boo's like, don't tell me you all did that, because they came back and didn't say anything. And he says Woody got scared because, and he says, Moncho, who's the person who calls, says, I have $10,000 of whoever did it. So to me, this is my rendition of this. Zachary kind of is like, I know that on some level they did it because they suspiciously leave, come back, and then he gets this call of who did it. And then Kenneth Copeland starts acting paranoid when they're saying, I have $10,000 on the head of someone who did that. Coupled with, and I don't have direct evidence of, on this date, Mr. Copeland told Zachary, I did it, or Mr. Stillwell or anyone told Mr. Zachary that, but I couple him being present around them shortly after this happened, coupled with his just daily interactions with him, that he actually has more, his knowledge of Lucci's mother's house, he was not present, but is less speculative than it may first seem from interacting with co-conspirators.
Okay.
That's my argument on this. But given the court's earlier rulings, I wanted just to highlight it came out more speculative when we addressed this incident.
Okay.
The earlier
And so here, Zachary is saying that he is at whoever, Big Boo's grandmother's house with Woody and whomever, and they leave, and then word comes in that Lucci's mama's house gets shot up, and then Woody and them come back while a phone call is being taken about whoever did this, there's a price on their head. And then Woody acts really suspicious, is what you're saying.
That is a much more concise rendition of what I just said, Your Honor. Yes.
Okay.
I have that large block starting at that certain time. And so, yes, that is my understanding of what Zachary says. That he's at a house with them, they leave, they come back, they realize it happened, and Mr. Copeland acts suspicious, which is decent clues of possible involvement. And I believe, I have no evidence of this, I just believe that coupled with they tend to talk amongst each other about what happened over time.
So on 110, unless it's transcribed wrong, I guess it's Detective Gaither says, so they actually came back and said they did it, or y'all just assumed it? And Zachary says, no, they said they did it.
That he says he finally said it, and Mr. Zachary says Woody, which is unintelligible. He says Woody. Like I told you, Woody got scared when they said they got $10,000.
Okay, and then on the next page, it says, and then what's the unintelligible part there?
He's like, man, just shut up.
Okay, well, that to me is him actually saying, we did that.
Shannon, saying it.
Okay, well,
Your Honor.
well, Mr. Copeland's not saying I did it, he's saying we did it.
What I'm saying is I don't know what I've never heard Mr. Copeland's in-court testimony about this and what that would be, but it's certainly not an admission by a party opponent that can be used against Mr. Stillwell, because there's nothing in here about Mr. Stillwell saying he did anything. And I don't know how, I mean, it's hearsay, and I don't know what exception this would fall under. I have a theory of what the state may argue, but
Okay.
it's not furthering anything. Except Mr. Copeland is apparently paranoid or whatever, and maybe he has some self-interest he's dealing with, but I'm not sure how it furthers anything. And so I don't want my client to be wrongfully linked to uncharged, well, I should say not substantively. And let me just say this too. No one's been charged with this act.
Okay.
It's listed as an overt act, but no one's been substantively charged with the actual crime.
All right. So who all is, I mean, I get that Zachary is at the house, at the grandmother's house, and Woody is at the grandmother's house and then leaves and then comes back. Who else is at the grandmother's house, leaves with Woody and comes back, if anyone?
So, Your Honor, I believe, so the closest I get is when they ask him who did it, he says Woody, Shannon, and Little Pokey. And he says collectively, like earlier he says, Woody's like, hey, let's ride, like collectively. And then he's like, they got back, or so my understanding is he doesn't definitively say this, but I believe either Shannon and Little Pokey were at the house and left. I'm just assuming from the way that he's speaking about it. And also, this is partly, it's the end of the day, but the court is correct that shortly thereafter, Mr. Copeland himself does state and says, you know,
and I mean, if
I did it.
If Shannon, and I guess Lil Pokey is not anybody that we need to concern ourselves with right now.
He is defendant Williams' nephew and someone that.
Okay, but he's not somebody on trial right now.
He's not on trial.
Or indicted.
He's not indicted.
Okay. All right. So I think it is fair to assume if Woody says, let's ride, and right after after Zachary said, here's the three people that I believe did it, and here's my reason for believing it. But in order, I think it potentially could be a statement if Mr. Stillwell shows back up with Mr. Copeland, and then Mr. Copeland's like, yeah, man, we did it. And Mr. Stillwell does not say, what are you talking about? I didn't do it. You might have done it, but don't count me in on that. Then that might be an admission because he's adopted it by silence, but not if he's not there when it gets said. So, you know, if you can establish that when Woody says, yeah, man, we did it, that Shannon's standing right there with him, knowing there's $10,000, you know, on his head, then yes, but otherwise, no.
Understood, Your Honor.
All right.
Your Honor, can I ask one small part on that? Yeah. In regards to taking aside defendant Stillwell, in regards to what Copeland referred to Zachary, that's appropriate, depending on how testimony of Mr. Copeland comes out, coupled with foundation for Mr. Zachary.
Yes.
Okay. Thank you, Your Honor.
And that might be one of those times when we might need a limiter if that comes out.
If I understand the state's question, they're saying, can we get into the fact that Kenneth Copeland admitted involvement?
Right, yes.
Without bringing Shannon.
Right,
it.
that was the second question, yes.
If we can't get to the adoptive admission.
Yes.
I don't have a problem with that.
All right. All right. We just have a lot to get done, but these are Mr. Zachary's only two statements that we need to get through, right?
Yes.
And we're about halfway through, I think.
Yes.
Assuming Mr. Copeland, to try to figure out scheduling, assuming that Mr. Copeland does not testify now, then y'all need to move to your next witness, right? Yes, right, yes. So, and I know Zachary's one of the next ones up. He may not be the very next one up, but is there another, witness that we would be hitting next week? Because after next week, the jury already had a week off, so we can do this delightful stuff that week, the week of the 19th, with regard to future witnesses. But are there other witnesses that, assuming Mr. Copeland does not testify, that we would reach next week whose evidence we have to hash out?
Yes. Mr. Sledge is the other person that
Okay.
but his interview is smaller.
Okay, can I go ahead and get that interview? And you have listed also a jail call, right?
Yes.
And then social media. And when can you get the more detailed information? This was supposed to be here today about at least these witnesses to the defense, not social media, but what? And they may have it, but if they don't have it, we need the detail. Yeah.
So can we provide that to them before, like in the morning, or like?
Do you have any of it ready right now? Because I know that your person working on it had been worried that he or she could not finish it all as to the first 30 witnesses, but surely he or she has accomplished the big chunk of it by now, right?
So those were the exhibits that she was working on. So we had the court had instructed us about the exhibits. And so that is what that person was working on. And I was hashing out the pool of the 30 witness exhibits that we were introducing.
All right, so how far along are you into that? Have you done like page one of it? I mean, I assume you're going in the order that you.
So can I, will the court so may I send to the court or to defendants into the court by 9 o'clock tonight? So everything that I have compiled.
Can you just send right now or in the next 45 minutes what you have so far? Because I'm sure that, what I suspect is that everybody would probably like to get some sleep, but that's not the reality of being in a trial. And so the sooner you can get them the stuff, the better. So let's not wait till 9. Let's, in the next hour, get what you've got right now over to them and me. And hopefully it'll be a big chunk of it. Okay, so, and then you need to send me, I assume the defense has a copy of Mr. Sledge's interview.
Yes.
Have y'all done this same exercise for Mr. Sledge to figure out what portions of it you need to object to? All right.
No, I will say Mr. Sledge's interview is shorter.
Okay.
And it's really confined to the incident that he's charged with.
Okay.
Which is the shooting up of houses he was charged with back in 2015 that him and Mr. Zachary pled to.
Okay.
It was taken after being arrested for that.
Okay. So I'm thinking that potentially the defense might have objections to social media, the defendant interview, or jail call or calls. But I don't know that. Do y'all know what you're going to get them, the specific social media? All right.
Yes, and Judge, just for
Yeah.
a point of clarification, we were trying to include on it the exhibit numbers. That's what
Yeah.
I was.
All right. Well, that's wonderful.
But,
But
so if some,
if the exhibit numbers aren't perfect, fine, we can fix those. Is that what your concern was? Okay. No, my concern is more that the defense get the evidence you're planning to use, because they need to be able to contemplate it and figure out how they're going to deal with it. All right. So, which means that if we're doing the trial next week and it isn't a couple of days of Copeland and then a couple of days of Zachary and people who, you know, there aren't going to be a lot of objections to, I mean, we need to have hashed out this with regard to all of next week's witnesses.
yes.
And how are we going to do that? Who all do you think there's going to be objection about other than Sledge and Zachary? And y'all, I'm looking at this giant list of witnesses from the state and looking at the first ones. And surely y'all have looked at most of this. Do y'all think that there's another witness coming up soon that we're going to have a lot of this kind of detail to hash out for?
No, well,
I mean, you don't think so? Okay, great. Does the defense think so?
So, Your Honor, so far, the state has seemed to be trying to introduce prior statements through the witnesses that are on the stand. Detective Thorpe and Michael Sprinkle, ADA Sprinkle,
Mm-hmm.
both conducted multiple interviews. I don't know to the extent that they're going to seek to introduce any prior statements through them, but that's the only thing that I can see. Mr. Sledge has a prior interview,
Right.
but my recollection is it's very confined to one incident, and he doesn't say, I'm going to review it, of course, but he doesn't say anything about anyone other than himself and Mr. Zachary, mostly,
Okay.
my recollection.
Okay. Thank you. Anybody else? See something that's going to be a whole lot of what should have been motions in limine?
Your Honor,
Yes.
trying our best to give you an estimate of what we think might be at issue. I'm looking, for example, at number 8, Michael Sprinkle.
Yeah.
So yes, we're aware that he conducted multiple interviews, but what we don't know at this point is what interviews it is that they intend to use. So we don't really know how to
All right.
address that. We also don't know what social media
All right.
items.
I think we're going to have a whole lot more of that in an hour. Tell me this, Miss Love, assuming Mr. Copeland does not testify, what witness do you think we are going to be at by next Friday? Keeping in mind that y'all will be here at 8:45, the jury will be ready to go at 9, and we will work till at least 5:30 most days.
I'm going to.
With a break for lunch and a couple of bathroom breaks, and that's about it.
So, thinking, no further than, and when I say Agent Bernie, it's for these records that we have, not for the
Okay,
ones that.
right, we talked about earlier, yeah.
But we will get no further than Agent Bernie.
Okay, all right, and so will what you send in an hour cover at least through Agent Bernie with detail about what the evidence is going to be? Okay, all right, okay, well, then we'll take it from there tomorrow. Let's be here at 8:45 tomorrow. And y'all think about the things that I asked you to think about and have some kind of proposal for me.
Are we completely abandoning for now the Zachary statements, or are we picking that up tomorrow?
No, I want to get through Zachary tomorrow and then move on to Sledge and then whatever else. But no, we're just abandoning that for now. It's time to go home.
Understood.
All right. Do we need an electronic? Mr. Atkins, could you send over an electronic copy of this transcript of the interview we're going through right now?
Yes, Your Honor, I will.
Thank you. All right, we're adjourned. Excellent, thank you. Give the original.